Hello to everybody. Hello.
Hi there.
Good to see you. The last day of our round table.
Yes. Hi, Helen. How are you? I'm fine, thanks. But like I said, it's exciting also now that it's the last day. So I look forward to that. Forward to the two roundtables we have today.
Yeah.
Yeah.
We have quite many speakers, and I do hope it's not too tiring.
Yeah.
Hello, Sergey. How are you? Can you hear me?
Yes, Wojciech.
Excellent.
Nice
Very
to
good.
see you.
Welcome, everybody.
Hello, Wojciech. Hello.
Hello. How are you? Oh,
I'm
Stalin.
fine,
Hi.
thanks. How are you? Good to see you.
Good to see you too.
So we have all the participants. I check. So Maximilian is here.
Yes, I'm here. Good afternoon.
Good afternoon. Tatiana is not yet, I think. Okay. Alberto
Yes,
is
here we are.
yeah.
Good morning.
Thank you. Carol is here, I see.
Yes, I am.
Yes, and Jakob is here as well.
Good morning.
Good
Hi.
morning. Right. Oh, here is Tatiana. Perfect. Now everybody's here, and it is 12 o'clock on my clock, so I think we can start. I'm very delighted to present our third panel of Young Scholars session. And today we have 5 speakers. We have 2 hours and 30 minutes, but I do hope that we will manage to make it a little bit shorter, because unfortunately we don't have a break, neither for us nor, which is more important, for the interpreters. So that's why I do hope that we will try to make it in about 2 hours or alike. So I ask every speaker to be as short as possible, and you have about 15 minutes at least, but please do not speak much more than 15 minutes. Okay, so I think we will have all the presentations, and after all the questions and discussion. Now let me introduce the first speaker, who is Maximilian Hau. Maximilian is PhD candidate in the University of Warsaw and Faculty of Law. And the topic of his presentation is marginal appreciation versus constitutional identity, the case of freedom of religion or belief. Maximilian, floor is yours.
Thank you for the introduction. Good morning once again to everyone. I would like to start with saying thank you to all contributors and organizations involved in this roundtable, and to express my regret that we are not present physically in St. Petersburg, which I always wanted to see. So anyway, to start my topic. Okay, so As it is well known, one of the primary challenges to the European Court of Human Rights is to, on the one hand, respond to demands of people living in countries constituting Council of Europe to deliver common standard in protecting human rights, and on the other hand, to cooperate with and hold its authority within those 47 politically and culturally different countries. Although there are voices calling for both uniformity and sovereign-based approach, I think that after declaration of Brighton and Brussels, as well as protocol number 15 amending the European Convention of Human Rights, a focus point was set on notion of subsidiarity. And it seems there is no return to uniformity approach in current political and legal context. So the key question is, what is subsidiarity about? What does it mean that the convention delivers subsidiarity system to national ones? I would like to focus, as Jay Gerard does, on judicial strategies, which are tools determining the scope of court supervision on state. Judicial strategies are not only legal argumentation methods, because in the broader context of the system established by the convention, favoring one of the judicial strategy approaches constitutes at the same time political choice. In the scope of subsidiarity issues, two strategies play the prominent role: margin of appreciation and constitutional identity. In my presentation, I will point out certain features of margin of appreciation and constitutional identity, which seems to be especially interesting in the perspective of the mutual competition. Then I will tell why those features speak in favor of margin of appreciation when it comes to provide a common standard by the court. In conclusion, I will refer to new approaches to margin of appreciation. The subject matter will be illustrated on cases concerning violation of Article 9 for at least two reasons. One, the member states are granted wide margin of appreciation when it comes to religious issues, but at the same time, there are fields where the court invented quite high protection standards, as in the case involving rights of a religious association to obtain legal personality. And two, Article 9 cases like Lauzi or SAS can be seen as constitutional identity reasoning examples. So, margin of appreciation as a subsidiarity instrument. Margin of appreciation was initially a judicial construct, but over time, through the Protocol 15 to the Convention, will soon become formal instrument, which allows the courts to minimize or maximize scrutiny of the review of the Convention violation. The purpose of margin of appreciation is to mitigate the tension between particulars of states and need to establish common standards of human rights protection. A lot has been written against margin of appreciation, but there are at least four features speaking in favor of it. Firstly, margin of appreciation applies only to the review of measures taken by the state, but not to the definition of the scope of rights, which should be stable through the Council of Europe state. Taking into account all margin of appreciation criticism, the conception does not allow the court to interfere with the substance of the protected convention rights. Secondly, margin of appreciation is open for trends or new approaches to establish social practices. In legal doctrine, several factors standing for use of margin of appreciation in particular cases are distinguished. The main, but also the most controversial one, is the common ground factor. If there is consensus on a certain matter, the margin of appreciation will be narrower and vice versa. Lack of clear court's procedure in the scope of determining the existence of common ground constitutes very serious allegation to margin of appreciation. Nonetheless, the common ground factor can be seen as an opportunity to the convention system. Consensus factor complements with the living instrument doctrine and the subsequent shared practice within the meaning of Vienna Convention. And so it guarantees that what is consensus today may change over time. And what is more, as Kay Henhart puts it, it is the court who decides when the turn was made. And it means that the power to decide whether certain social practices has changed, dismissed, or occurred lies on the court. Thirdly, margin of appreciation cannot be applied to all convention provisions. When the case concerns absolute, non-derogable provision like Articles 3 or 7, the court will not allow the state any discretion as regard to the level of protection. Such a high standard applies also in relation to positive obligation arising from these provisions. Fourthly, margin of appreciation with all its defects, after all, delivers predictability of the court's judgment. There is a lot to do in this field, of course, especially as already mentioned, more attention should be paid to systematization of factors determining breadth of margin of appreciation and existence of the common ground. Nevertheless, the margin of appreciation still enables to anticipate what may be counted as an overrun of the margin of appreciation, and this predictability contributes to common standard. Lastly, being the court's conception, margin of appreciation has an autonomous meaning which reduces scope of state particularities. And now constitutional identity as a subsidiarity instrument. Constitutional identity, as we all know, is a vague concept, and the purpose of my presentation is not to deliver its precise definition. For this presentation, examples of constitutional identity will be second generation approach to jurisprudence relating to Article 9, by which M. Evans and P. Petkoff understood cases where violation of the convention was justified on the basis of the good which the majority approach or culture represents. Firstly, constitutional identity opposed to margin of appreciation is a non-fluid construct because it presumes that some values as well as actions inspired by them or justified by these values are part of the constitutional identity, which remains unchangeable. Article 9 cases like Lautsi or SAS are prominent examples because what was at stake there was to extend the meaning of neutral role of state. Neutrality was reconciled with protection of majority culture, and the arguments raised by states were referring to constitutional identity concepts like French living together. Secondly, as has been partially mentioned, constitutional identity is much more vulnerable to transfer social values into legal reality. It should be agreed that most of the time identity is a shorthand for majority. With respect to constitutional identity, precise designation of its source is impossible, which makes the constitutional identity dependent on current political background. The constitutional identity should be placed within militant democracy instruments because its purpose is not to ensure justice from the third person impartial perspective, but rather frame certain values in a way neglecting others for the purpose like threat to democracy, however it's understood. Thirdly, constitutional identity is oriented on its integration in particular, so it hardly contributes to establishing common standards. Also, when it has been applied, it becomes unenforceable and of course easily arbitrary. Scope of potential constitutional identity is limitless because basically any value theoretically may count as essential to identity. So why margin of appreciation is a better subsidiarity tool? As I mentioned at the beginning, in nowadays context, there is no escape from subsidiarity dominated discourse in relation to conventions. I think that more attention should be paid to contribute to margin of appreciation doctrine than its criticism, because second option on the table, which is constitutional identity, I find much worse. And why is that? Margin of appreciation does not interfere with the substance of the convention rights. Margin of appreciation focuses only on measures taken by the state, contrary to constitutional identity, which aims to define rights and values. Reflection of notion of neutrality illustrate how culture and practice of majority may designate as neutral. Margin of appreciation is open for social changes because it is grounded on consensus between the states. Constitutional identity instead is founded on those values which preserves and change over time. And what is more, margin of appreciation lets the court to decide on when the turn in social practice occurred, while constitutional identity brings this power back to the states. Constitutional identity will always save in favor of majority against minorities. It does not have to be also the case of margin of appreciation. Court's judgment on religious group rights to obtain legal personality show that even if states are grounded a broad margin of appreciation, like when it comes to Article 9, the court can still ensure high level of protection of minorities. And despite the fact that margin of appreciation grants subsidiarity to states too, there are rights excluded from its scope. Otherwise, constitutional identity is typically anything goes our instrument because anything may be said to be identity essential. And lastly, constitutional identity is a super vague concept, ultra sensitive to political concept and almost impossible to conceptualize for the court's use due to its essential particularity. It is also essential an instrument out of the conventional word since it was not invented by the court or present in the convention text. For all of this, it will never contribute or hardly contribute to strengthening the common standard of the convention. So conclusion, to sum up, margin of appreciation is a much better instrument of balancing the values of subsidiarity on the one hand and contributing to the common standard of human rights protection on the other hand. And Article 9 cases regarding registration proves it. J. Gerard claims that margin of appreciation is no longer important for mitigating the tension between respect for national differences and need to respect fundamental rights, as well as providing clarity to states how the convention rights should be applied. She indicates incrementalism and general principles approach as new judicial strategies relevant in the subsidiarity field. And I agree with this position. I think that this may answer to serious defects of margin of appreciation, like designating the existence of consensus between the states. But what is more important, contributors like Gerard shows that margin of appreciation is in some kind alive and needed, and efforts should be made in this direction. I think that otherwise conceptions like constitutional identity will become more and more popular with the purpose of focusing human rights away from the protection of individuals from the state toward the protection of the state from the individuals. And that's all, thank you.
Thank you very much, Maximilian. Very nice presentation. We realize that you prefer margin of appreciation than constitutional identity. So our next speaker is the only speaker.
Kardeşin aradı. Telefon bekliyor senden.
Selim, may I ask you to switch on the mic? Selim?
Oh, I'm so sorry about that.
Our next speaker is the only speaker in this session who is not PhD candidate, but associate professor in High School of Economics, Moscow, the Russian Federation, Tatiana Khramova. Tatiana, the floor is yours.
Thank you so much. It's my pleasure to express my great gratitude to the organizers again, and to be a part of this interesting and wonderful conference. And thank you to the organizers, and my warmest welcome and my warmest greetings to all the participants. I hope you see the presentation, and I'll try to stick within time limits. So the topic of my presentation is the possibilities and limits of evolutive interpretation of constitutional principles. So how I came to think about this topic, well, I was reflecting upon the recent and widely mentioned, especially during this conference by Russian scholars, judgment of the Russian Constitutional Court on constitutional amendments 2020, and I actually the puzzle that I came to was that the Constitutional Court, in my idea, was confronted between two contradicting tasks when deciding upon the constitutionality of constitutional amendments. So on the one hand, the court was kind of supposed to protect the core constitutional commitments of the Russian Constitution and to maintain a level of stability, while on the other hand, to put it in the words expressed by Professor William Bartlett, to allow varying constitutional practices or to allow some transformation within the intact constitutional principles. And so those were two quite difficult and two-folded tasks. And I'm afraid that I believe that Constitutional Court failed on both of them. And so I decided to make my presentation on actually possible methods, the possibilities and difficulties of interpreting constitutional principles as enshrined in the Russian Constitution, and then maybe introduce or maybe reflect a little bit about the evolutive approach to the interpretation of constitutional principles and how it is performed, for example, by the European Court of Human Rights, and how it should have been performed. And then I will jump to my brief comments on what was wrong with such approach to interpretation of constitutional principles in the judgment of the Russian Constitutional Court. And again, it has been mentioned already during this conference by some of the prominent speakers that Russian constitution, like many other constitutions, contains a set of basic, fundamental, quite abstract principles enshrined in chapter 1. And then there is also chapter 2 on basic rights and freedoms that are both of those two chapters form the foundations of Russian constitutional order and are protected by other chapters of the Constitution, including chapter 9, and those three cannot be revised except for by adoption of a new document. So these principles, in essence, and the Constitutional Court of Russia used to say that reflect the constitutional identity of Russian Federation. And on the one hand, they are quite universal. So they include the principles of democracy, rule of law, republican form of government, separation of powers, federalism. On the other hand, they may be claimed country-specific, possibly in their unique combination. And maybe if we add to all those principles the notions of from the preamble to the constitution, then we kind of get a unique form of Russian constitutional foundations or constitutional principles, the foundations of constitutional order. Most of these principles are quite functional, so they may be rationalized and they may be interpreted in a rational way. Some provisions, mainly in the preamble, are expressive, and we may attribute them more to this identity concept. So to conclude from that, we may say that the constitutional principles are too abstract to apply them directly. So they require interpretation for sure. And that task was, in the case of 2020 amendments, control entrusted to the Constitutional Court. Another important idea that I have already touched upon is that the principles are not meant to be preserved intact forever. So a constitution is, on the one hand, a stable document, but on the other hand, a living instrument. Therefore, the Constitutional Court, interpreting those principles, has a wide number of methods or approaches to interpretation of those principles to ensure both the stability by textual, by systemic approach to interpretation, by historical or originalist approach, or by purposive methods of interpretation. And on the other hand, to ensure the possibility of change, the possibility of evolving consensus, the possibility of progress. And for that, for the second purpose, the court also has some methods or some techniques to apply. And one of them is the evolutive interpretation, which is, I'm not really sure if it's a completely separate method of constitutional interpretation, but maybe rather a mixture of other methods. But for example, the European Court of Human Rights recognizes it as an approach to interpretation of the basic foundational principles, and therefore I use it in this sense. So as the Russian Constitutional Court does not have a theory of or a clear methodology of how to apply this evolutive approach to the interpretation of principles, we may look at the European Court of Human Rights, which has quite a good practice of that. And in the literature, we find two basic methods of evolutive interpretation, that is strong change and weak change. And actually, if we look at the Constitutional Court practice, it applies both. A strong change involves a big step forward, maybe a rejection of previous viewpoint. And an example I would claim would be a moratorium that the Russian Constitutional Court introduced on the death penalty in 2009, changing its position, not rejecting, but really drastically changing its viewpoint on this matter within the same text of the Constitution. A weak change is a more incremental step forward. It doesn't involve a reversal or change in the legal position of the court, but rather expanding the scope of some principle or norm, or applying it to a different set of circumstances, adjusting it to the current development of social relations, like applying the right to private and family life to artificial reproductive technologies, or applying freedom of speech to the internet, and so on. So the Russian Constitutional Court also engages in such a method. So why would the need of such an evolutive interpretation appear in front of the court, which is, again, not a political institution, but rather a neutral arbitrator? Well, first of all, it may be, the reason may be that the standards of protection of a certain right or a principle are moving forward, are progressing and increasing. So in this regard, the European Court of Human Rights already has a position expressed in numerous decisions, and it justifies an evolutive approach to interpretation of the basic provisions by this moving in the direction of the progress of rights and progress of constitutionalism, let's say. The second reason why the court may need to invoke evolutive interpretation is to bring the national standards of protection or national understanding of certain concepts in conformity with the recognized international standards, which again evolve. An example would be when a country signs or ratifies an international instrument document, it may then update the understanding of certain principles, let's say in the environmental protection sphere or in others, to change its own national standards and lift them up a little bit. And the third reason would be the evolving internal consensus, or the changes in the constitutional identity within the state. This is a very tricky concept, I would say, a tricky reason, I would say, because it involves quite some risks. And the risks actually of evolutive interpretation are quite high, I would say, on both international and national levels of interpretation of basic structures. Well, first of all, to respond to the first reason to invoke this method of interpretation, the court may switch not to a progressive, but rather to a regressive interpretation of rights and freedoms, or fundamental concepts, and that is a very high risk. And the European Court of Human Rights, for example, explicitly rejects such an approach. Unfortunately, in the practice of the Russian Constitutional Court, we see such a regressive interpretation of, for example, a right to participate in the government, voting rights. Another risk, high risk, is the risk of judicial activism or too much involvement of the court in deciding political matters. When the court starts inventing new approaches to constitutional interpretation, it kind of gets engaged in the political game, let's say. And then the third risk that I already mentioned briefly is that this tricky notion of evolving internal consensus within the country, as it is such a vague and non-legal term. It's totally extra-legal, and the court is probably not well positioned to evaluate the social reality and the context. Therefore, there is a high risk of manipulative use of this argument, the argument of evolving consensus, the argument of specific historical moment that should be taken into account, the argument of special economic, political, and whatever circumstances that should be considered when interpreting the basic fundamental provisions and so on. And unfortunately, we also see quite a frequent referral to these vague concepts in the practice of the Constitutional Court. So now briefly, having all the, introduced my understanding of this approach to interpretation, let me comment a little bit on what went wrong with the interpretation of the constitutional principles in the judgment of the Constitutional Court reviewing the Constitutional Amendments 2020. Well, the text of the amendments very clearly defined the role of the Constitutional Court in this process, and that is to check whether constitutional amendments to chapters 3 to 8 of the Constitution do not contradict or are in conformity with the fundamental provisions of chapters 1, 2, and 9. So to do that, in my view, the court could engage in the interpretation of the meaning of the basic principles and apply different methods to interpretation, text and structure, systemic approach, originalist approach. Maybe if the court wanted to keep the meaning of some principles intact and clearly original. Maybe the possibility of weak change was also possible, meaning that the understanding of principles would not be changed completely, reversed, but rather a step would be made forward to adjust the principles to today's reality. Instead, the Constitutional Court engaged partially in strong change interpretation of some of the principles and did not really make full use of the potential of substantive interpretation of the principles. So what it did in one of the failures, I think one of the main ones, was that it applied a very formalistic, even simplistic approach to understanding the substance of constitutional principles, making them hollow but not normative concepts. And one of the demonstrations is when the Constitutional Court said that the new procedure of removal of judges upon the discretion of the president does not violate Article 10 of the Russian Constitution, which enshrines separation of powers and checks and balances, meaning that this principle, in essence, does not require any specific guarantees of judicial independence and does not really have any normative significance. The second failure in my idea was an unjustified appeal to constitutional identity in the interpretation of the new amendments. So as I mentioned before, previously the Constitutional Court defined constitutional identity in the 2015 decision, for example, as the foundations of constitutional orders enshrined in Chapter 1 and accompanied by a list of fundamental rights in Chapter 2. But in this decision, in this judgment, the Constitutional Court kind of expanded and, in my idea, discredited the notion of identity, stating that some of the amendments actually touched upon the understanding of all Russian state identity. The court used this term, and therefore interpreted the identity in the light of the new amendments. In my view, that was completely unjustified. The third failure, I would say, as I already mentioned, was the application of a strong change approach to one of the actually several of the constitutional principles, rejecting the previous understanding, and that could be explained by the example of lifting the limits on the number of presidential terms. Before the judgment in the 1990s, the Constitutional Court demonstrated a substantial understanding of the principle of rule of law and Republican form of government as requiring a set of limits on the number of terms, of presidential terms, while in this particular judgment, the court reversed its understanding, again, turning to formalistic interpretation of the principles and allowing an exception from from application of these principles. The fourth failure, and that is the last one, and then I jump to conclusion, is that the court, again, in my view, without any justification, used some emotional rather than rational argumentation and applied to these vague extra-legal notions of a special historical moment. And I quote here in my English interpretation of English translation of the judgment, the level of threats to the states and society, the conditions of political and economic system, when it explained the need to make an exception in understanding of the principles without actually justifying those threats, the specific conditions, and so on. So in essence, what the court did, by such a weak emotional review, it kind of gave the leeway to constitutional legislator. And this is a part of my modest conclusion from that. So to summarize, the judgment shows that the Constitutional Court did not make use of this new power given to him, first ad hoc by the law on constitutional amendments, and now this power is actually vested in the Constitutional Court by the Constitution and the law on the Constitutional Court to actually substantively review the amendments and produce an interpretation of basic foundational constitutional principles. It denied the principles their normative value, and it kind of denied the integrity of the Constitution, the internal structure that puts chapters 1 and 2 on top, and then the rest of the chapters that must comply with those first two. It, in a sense, discredited the concept of constitutional identity, expanding it to other notions without any justification, and it overstepped the limits of evolutive interpretation by applying a strong change approach and by manipulating the historical moment and political circumstances arguments, let's say. And in the end, by doing that, the Constitutional Court kind of stepped back and gave unlimited discretion to the constitutional legislator to alter the Constitution. We'll see if this was just an ad hoc approach, or if this may continue in the future, because, as I mentioned, the power of the Constitutional Court to review amendments has just been included into the Constitution. So we'll see how it goes, but according to my modest analysis, we have not really many reasons to be hopeful. And I would thank you. I will finish on that, and we'll be happy to answer any questions.
Thank you so much, Tatiana. You demonstrated, especially for our foreign colleagues, what the Justice Mavrin and Justice Gadjiev meant when in their presentations they mentioned the use of concept of constitutional identity by the Russian Constitutional Court. Thank you, and I do hope your presentation will meet some discussion as well. So our next speakers, we have co-authored presentation by Alberto Nicotina, PhD candidate in University of Antwerp, Belgium, and Emile Martini, who does not keep any academic position at this moment, but holds LLM degree from College of Europe, Belgium as well. Will you speak, both of you, or just
yes.
one? Okay, so please, you have 15 minutes for both. Please
Thank you very much. Thank you very much. Thank all of you for organizing this and for having us here. So our contribution is certainly in line with the presentation we have already heard over the past few days and today, but it is limited geographically to the territory, to the borders of the European Union. The title of the presentation is The Other Heading, National and European Identity, a Dialogue-Based Approach. What we are going to talk about is indeed the European identity. We will find a theoretical framework to indeed frame this issue of the European identity. Then we'll try to develop a legal viewpoint on this dynamic, this tension between national and European identity. And we'll try to draw some concluding remarks about that. So first of all, our main research question is, does an EU constitutional identity exist? And indeed, to frame this question from a theoretical point of view, theoretical philosophical point of view, we decided to take as a starting point the contribution of a French philosopher, Jacques Derrida, in his book, The Other Heading, Reflections on Today's Europe. This is a book that has been written in 1991. It is the transposition of a conference Derrida held in Turin, in Italy, in 91. It was an historical moment in which a constitutional treaty was discussed, and the topic of whether European identity existed was very, very on point. We'll ask ourselves what is identity, what is European identity in particular, and how to reconcile national and EU identities. We take Derrida as a theoretical reference because he's the father of deconstructivism. Deconstructivism is that strain of postmodern philosophy that invite all of us to constantly put into question all the notion that in our daily life we give for granted. And we are invited to consider reality in its complexity without eliminating contradiction. This operation leads to what Derrida calls aporia, by taking into account and reproposing a concept that was a founding concept of the Greek ancient philosophy, which is translatable in English as puzzlement or impasse, taking into account all contradictory elements, making the agent feel as lost. And it's what Derrida calls this experience of the impossible. And I think, and we think, that this theoretical framework is particularly useful to think of European identity, because in the context of European identity, we have this tension indeed between national identity and the identity of the European Union. Maybe Emil, we can continue here.
Thank you, Alberto, for your first part. Now I will try to briefly discuss more and describe the legal evolution in the European treaties of the notion of identity. First of all, with the Maastricht Treaty, the identity topic made its first appearance in the European legislation, and it was disposed that the Union shall respect the national identities of its members, whose system of government are founded on the principles of democracy. And the formulation adopted in Maastricht showed that the main concern related to national identity was essentially a political one, to defend national democracy. And in this phase, cultural and fundamental rights-driven conception left room for a more pragmatic defense of the state's fundamental structure. Some years later, in the Amsterdam Treaty, national identity was disconnected from the democratic principles. And after an enumeration of the European Common Principle at the first paragraph of Article F, national identity appeared only at paragraph 3 as a general counterbalance that was detached from any other specification. And so this provision, as well as the Maastricht's one, was interpreted by the doctrine as having no legal meaning. Therefore, national identity was not justiciable and representing nothing more than a political reassurance for member states. And the origin of the identity clause, as we know it nowadays, dates back to Article E5 of the Constitutional Treaty. This article, compared to its predecessor, responded to a quite different dynamic, being strictly related to questions of competence. And with its new formulation, it appeared clearer than before that by expanding the concept of national identities so as to include the member state fundamental structures, and by introducing a duty to respect essential state functions, the drafters sought to carve out core areas of national sovereignty, as no list of member state exclusive powers was eventually included in the treaties. So let's say that to protect the national prerogatives, four solutions were envisaged. The first suggestion, called a community model, consisted in a sort of negative delimitation of EU competence made policy by policy in the treaties, specifying in every single case what the Union cannot do. The second suggestion, called the Union model, required to expand the whole identity clause by adding language to the effect that the national identity of the member states includes the constitutional and political structure of the member state, including, for example, regional and local subdivision, administration and enforcement that were not exceptionally otherwise provided in the treaties. State and church relation, for example, policy with regard to the distribution of income and maintaining and improving social welfare benefits, etc. Then a third proposal, referred to as the constitutional model, implied the formulation of a provision on member state reserved areas. This was more a positive approach that consisting either in a general article reaffirming the principle of conferral, so what is not transferred remains at the national level, or in a narrower statement enumerating the most important remaining areas of member state competence. Lastly, the so-called political model proposed a charter of member state rights with the purpose of clarifying for the citizens the scope of national competence. Dealing with this topic, both the member states and the Commission put at the center one objective, that is to contain the EU competence creep. In the end, the final drafting of Article I5 of the Constitution, not surprisingly, was the result of a compromise between the different actors and visions. So the final result is in the Treaty of Lisbon, where the identity clause seems to be even more linked to the competence issue. From the outset, the national perspective seemed to be that of the necessity to preserve the main of member state sovereignty and of their characteristics, structures, and values. Such a need has become more and more intertwined with the static defense of member state prerogatives through an attempt to specify areas to be excluded from any kind of influence of EU law. However, this approach does not take account of the fact that the European legal system, as we know it today, is struggling to leave areas where European law has no influence whatsoever. In addition, such an article cannot represent a trump card allowing each member state to unilaterally derogate from EU law, but on the contrary, the notion of national identity should be a flexible tool which defends values and structures that go beyond a clear division of competences. And in the end, we think that this flexibility is the key. And as also Advocate General Maduro pointed out in several occasions, the constitutional courts are the most appropriate bodies at the national level that should be in charge of filling this empty box that is represented by the national identity clause. So by virtue of their role as guardians of national constitution, they are actually trusted with this role that is preserving the identity of the constitution and interpret constitutional text. And on the other hand, we have also the ECJ that needs a valid interlocutor who can help define a concept that by its very nature remains closely linked to the national dimension. So as we have seen, we believe that the most qualified interlocutors in this regard could, in this dialogue also with the ECJ, could be the constitutional courts. So the judicial dialogue is the change of perspective that we need on the topic of national identity. But we know that it's not always easy to do, and new procedures can be imagined to this purpose. That's why now my colleague Alberto will show that we can find some solution on some ideas, maybe also on the other side of the Atlantic Ocean.
Yeah, indeed. What we think here is that if it's true that the constitutional identity of the European is consolidated in the dialogue between national, especially constitutional courts, and the European Court of Justice, maybe we can also find some other tools to promote, to enhance and foster this constitutional dialogue. The comparison with the US system is interesting in our opinion. In the US, there is this a top-down system of certification of questions of state law. Whenever a federal court, even this US Supreme Court, has a doubt on the interpretation of a state law provision, it has the option, it's just an option, but it has the option to ask the federal court, the Supreme Court of a state, to certify the question. So to provide the original interpretation, the certified interpretation of state law. So it's a, let's say, a top-down system. In the European Union, we all know that the system in the country bottom-up. So are the national courts that when they have doubts on the interpretation of EU law, they can ask through the preliminary references the EU Court of Justice to deliver the appropriate interpretation of EU law. We think that, however, in the current European legal order, there is room for improvement and for other solution and other ways in which this dialogue can take place. For instance, the tools granted by the rules of procedure of the European Court of Justice that allow the European Court of Justice to ask for clarification to state court, that could be a useful tool, for example, to make this constitutional dialogue a two-sided constitutional dialogue. And we think in the end that this idea and this two-sided constitutional dialogue could make it real, could really implement Derrida's vision about an identity to make. Thank you very much.
Thank you so much. It's very interesting dimension, which was the item for discussions and for presentations of some other speakers about the EU specific of constitutional identity regulations. So thank you for your contribution to this very important point. And our next speaker is Karol Poplavski. He's PhD candidate in Akademia Leona Koźmińskiego, Warsaw. And please, Karol, the floor is yours.
Thank you very much. What is typical for I think all the panelists. I'd like to thank for the organizers for this fantastic opportunity to present my insights. I think that also the panel was fit perfectly because I believe that my contribution will also be interesting according to what was said until now. So I will try to be as brief as it is possible. My main goal is to present that we have some certain of vagueness according to the correct terminology on constitutional identity and then the national identity. I think that in longer periods of time, treating those notions synonymically or
Carol, Carol, Carol,
yes.
I'm sorry to interrupt you, but the sound is very bad. Could you please make your mic a little bit louder, or use some device to for the interpreters to hear you better?
Okay, okay, and now it is better.
I'm not sure.
Okay, and now?
Well, no, they do not. I mean, the interpreters.
Mm-hmm.
They do not hear you clear enough.
Okay, so
Maybe a little bit louder.
okay, so I can try to say it more loud, and I and maybe more slowly. But is it better, or just I need to have some couple of minutes to for example, I don't know, some micro or something?
Okay. Well,
Because
just
I understand that
try
there
to
is
speak.
still a problem. Yes.
Try to speak louder if you can.
Yes, yes, I try, but
Okay. Okay, please go on.
it's okay. Okay, so we try to go on. Okay. So I'm very sorry for the disturbance because it was not intended. Uh, so as I said, that I believe that treating those notions synonymically is in the longer period of time leading us to nowhere, in fact. Uh, and I voted here some of the interesting aspects of the Article 4, paragraph 2nd of the TEU, on the basis on which the Union shall respect at first the equality of the member states, their national identities, the fundamental structures, political and constitutional structures of the member states, and also Union shall respect the essential state functions, including the territorial integrity, maintaining law and order, etc. Uh, as we know, in the European legal order, Article 4 creates uh, the exemption from the principle of the primacy of the EU law in some part. At the same time, constitutional identity being defined by the constitutional tribunals, uh, scope of my analysis will consider only V4 countries, but in fact the majority of member states present the constitutional identity as a set of principles which cannot be shared with the European Union, which defines the core of the Constitution. So that is why I present also the synonyms as the material core of competences, identity of values, or core principles of the state. Uh, I call this kind of identity, constitutional identity, a formal, because it is actualized in accordance with in relation towards the EU law. Uh, but also, I think that we can at least try to define the material aspect of the constitutional identity, which is rather focused on the philosophy, axiology of the certain constitutions. So it is rather close to what Professor Rosenfeld or Jacobson presents as the constitutional identity as a result of permanent discussion. The scope of analysis will include V4 countries because, in fact, they share similar experiences connecting the transformational period from the post-communism into the, let's call it, modern democracies. I would like to start with the Czech Republic, in which we can define the material aspect of the constitutional identity from the eternity clauses, which is the Article 1, Paragraph 1 of the Constitution and Article 9, Paragraph 2 of the Czechian Constitution. We should also emphasize the Article 1, Paragraph 2, Paragraph 2 of the Constitution of the Czech Republic, which states the duty to observe the obligations resulting from the international law. According to that, we can assume that formal aspects of the constitutional identity of the Czech Republic will be rather wide. And on that basis, we can, I think, draw following conclusion: that the Czechian Constitutional Court was presenting the open attitude for the international processes. It also created certain limits of competences of the EU, but they could not harm the principle of the primacy. And then also the court emphasized the necessity of mutual relations, mutual obligations, which we can present briefly like: we give you some part of our sovereignty, but we also want something back. But there is no discussion on the constitutional identity in the Czech Republic without mentioning the judgment in the Slovak pension case. Some authors point that it began the concept, it ignited the concept of the ethno-cultural constitutional identity. Regarding the terminology, it should be stressed that this judgment, because it was a subject of discussion during the panel on Thursday or Friday, I don't remember, where Professor Kuhn stated that it was just a bad day at work, just exceptional judgment, but it is sometimes mentioned in the Czechian literature and Polish literature on that issue that it somehow ignited the concept of the people's constitutional identity or popular constitutional identity, which is a rather open concept, a bit similar to what is it in Hungary. So that is why I think that some attention should be paid to this judgment, because it expressly denied the argumentation of the CJEU, Court of Justice of the European Union, on the Czechian constitutional order. Constitutional Court of Czech Republic said that, shortly speaking, that CJEU is not right, in fact, while defining some of the aspects of the constitutional law of the Czech Republic. In Poland, we do not have eternity clauses, so that is one of the reasons why Constitutional Tribunal had to define constitutional identity itself, and it stated that it's a set of principles which creates the core of the Constitution, which cannot be shared with the EU. But the scope is rather fundamental. It is the protection of human dignity, constitutional rights, principle of protecting the state, etc. as it is presented. It is rather a combined version of material and formal constitutional identity. What is important, because constitutional identity in Poland was also mentioned in Judgment Case 4509, but what draws attention is that it was treated similarly as a synonym with the national identity. Constitutional identity was mentioned a part of national identity of the Polish Republic. But while reading the judgment, we could see that Constitutional Court, in fact, divided those notions, because constitutional identity was a set of principles, whereas the national identity was oriented on the in order to secure language, history, culture of the nation. I think that the example of Hungary is a matter of other discussion, but shortly speaking, we should state that fundamental law of Hungary possessed different axiology. Despite the fact that the fundamental law of Hungary was introduced, was passed almost 7 years after the accession to the EU, so it knew perfectly well the EU law context. Uh, in my opinion, the modern, sorry, not modern, but different axiology of Hungarian constitutional fundamental law results from at least two aspects, which is the obligation to interpret Hungarian fundamental law in accordance with national avowal, which is the preamble to fundamental law, and to interpret Hungarian fundamental law in accordance with the principles included in the Hungarian constitutional historical constitution. It is sometimes mentioned in Poland that Hungary is the example where the national identity created the constitution and as a result the constitutional identity. And on that basis, it is an open concept, in fact, unlimited concept. And as a result, it's difficult to capture the essence of the national identity of the Hungary. But I will base on the most actual judgment on that issue, in which Constitutional Tribunal, Constitutional Court of Hungary presented at least both dimensional, both method of interpreting the constitutional identity, which is a sovereignty interpretation, which aim is to evaluate if the sovereign is not excluded from the competence to control the executive power, and the identity perspective, which is the, in fact, as it was typically presented, the set of principles. But what draws attention is the fact that the notion of constitutional identity was extended with the respect of the conditions which create the conditions of life in Hungary, which is the sphere of language, history, and culture. And on that basis, we should see that there's the example of how the national identity is in of the constitution. And it was not in its formal aspect, so it was not connected with the relation to the EU law, but it was connected with the process of amending the constitution. And Slovakian Constitutional Court presented that constitutional identity, the core of the constitution, is based on the principle of democracy and the rule of law, as well as on the independence of the judicial power. And on it should be stressed out that intention of the Slovakian Constitutional Court was to present the constitutional identity as a guarantee of certain democratic vision of the state and law. And that reminds the article, one of the articles of Professor Paraguna, in which he suggested that constitutional identity could be defined as a shield in relation to the EU, but also as a sword having certain positive implications. So in order to conclude this part of my assumptions, it should be admitted that constitutional identity concept in the V4 countries presents the set of principles which is rather universal for humanism, universal for common constitutionalism, but also V4 countries presented clearly that the concept of constitutional identity supports the concept of the tribunal of the last word. Thus, it makes the constitutional identity, at least in its formal aspect, rather political mechanism, enabling the constitutional court to create dynamic way of interpretation of the EU law and interpreting it in accordance to the law of certain member states. But those conclusions are especially important if we compare it with the Copenhagen criteria, because there's no doubt that countries of the Visegrad group had to follow the Copenhagen criteria because it was the condition of its active participation in the international process. And there is also no doubt that it had influence on its constitutional identity, because Copenhagen criteria created a certain vision of the state, certain vision of the separation of powers, and certain vision of the axiology of the law. So that limited significantly the sphere of the constitutional identity. And what is the paradoxical aspect, in fact, is that the constitutional tribunals of those countries present that their constitutional identity is based on certain principles, and that's okay. But those principles are at the same time uh, universal. And for those more than 15 years of active participation in the EU, especially considering the Polish example, Polish Constitutional Court did not present something unique in the interpretation of those principles, which in fact creates its constitutional identity. So that, I think, supports the thesis that uh, it is constitutional identity in its formal aspect is rather political mechanism rather than strictly legal. And to open the discussion on the European law, I'd like to consider also the example of Hungary, because if we recall the content of the Article 4, paragraph 2 of the Treaty on the European Union, we see that sometimes history is not historical, but political and constitutional structures, fundamental, are seen as, are treated as the synonym of the constitutional identity. But considering the Hungarian example, we see that their historical constitution, very vague and very a little bit weird concept, is undoubtedly political and constitutional structure. So on that basis, it could significantly limit the EU law on that aspect, but it do not fall within the scope of the EU law. I also state that the judicial dialogue still is not effective enough. One of the factors of that thesis, of that conclusion, is the fact that I'm afraid that national constitutional court will never limit its competence to interpret the constitutional identity of member states, because it would result with their with limitation of their powers. So one of the remedies should be that the Court of Justice of the European Union should have the right to interpret Article 4 exclusively, because the result of its functioning is the exemption from the primacy of the EU law. And the methods of those interpretations should be based on the margin of appreciation and interpretation in the light of the potential common traditions of the member states. But also, that interpretation ought to be literal and not extensive. If the first factor is not possible, at least now, I believe that Court of Justice of the European Union shall at least create certain methods of defining the national identity, and those methods shall be applied in each case. It would be the equivalent of the ultra-virus control and constitutional identity control, which is presented by several constitutional courts in European Union, for example, the Federal Constitutional Court of Germany, or even the Hungarian Constitutional Court. But does it all mean that those notions are completely different? Not really, because from the national identity principle, we can at least present three specific provisions, three specific principles, which is the protection of the national identity sensu largo, which I found the most significant, because I believe that in this aspect of the protection of national identity should be included the protection of language of member states, their culture, and their history. because those are factors which are rather difficult to integrate in full aspect, as a whole. But and there are numerous judgments of the CJEU and opinions of the Advocate General in which they present similar attitudes. The second is the protection of the fundamental competences of the state, and I believe that that should be the synonym of the constitutional identity, and thus Article 4, Paragraph 2 of the TEU presents certain ways where lies the fundamental competences of the state. It's order, but interpreted like the legal order and security of those states. Those are the fundamental competences of the state. I think that it should be limited, that these competences should be limited if it's up to the interpretation of the common values, especially if we consider as I mentioned, the influence of the Copenhagen criteria, at least in V4 countries. Also, it should be done in certain conditions, which are the impossibility to present extensive and preventive interpretation of those principles and its genuine fundamental character, which can be proved, for example, during the vertical and horizontal judicial dialogue. And the title of my speech is a little bit long, and because I wanted to make it a bit catchy, but I'd like to sum up with the question. I believe open question. Here in the picture, we can see the Prime Minister Orban, Prime Minister Morawiecki, and leader of our political majority, Jarosław Kaczyński. And I asked about, do the politicians see more? And it's not a coincidence, especially if you consider how Prime Minister Kaczyński is wearing his mask. But those questions concern, do the politicians define the problem in the identity, some kind of identity crisis in still young post-communism society? Because there is a certain question: are we European or national-oriented? Are we liberal and secular, or we create our collective identity on the religious values? And as a result of those questions, yes.
Carol, I beg your apologizes, but I have to remind you about the time.
Yes, that's the last slide.
Thank you.
Because in the title of my speech, I stated that we are somehow facing the process of the integration despite the law. And I think that there are at least three elements of this concept, which is the clear conviction that certain member states define its constitutional identity, at least for last 4 or 5 years, contrary to the community of values among EU member states. Second is the clear conviction that the EU preventive and repressive mechanisms are, at least at the moment, ineffective. Maybe it will happen in future, maybe it will change in future according to the conditionality mechanism on the rule of law. And despite that, the EU decided, according to the post-COVID situation, to strengthen the integration. So it somehow happens despite the law, because we know there is a significant breach in the unity of values, but we still open for further integration. So thank you very much, and once again, sorry for the disturbance.
Thank you. Thank you, Carol. It was very interesting presentation. And I forgot to say that Carol's topic for his thesis is the identity of Polish Constitution 1997. And here we had a presentation about the the national constitutional identities of some Central European states within the context of European Union constitutional or just union identity. And our next speaker, Jakub Gasperin, am I right pronouncing your name?
Perfect, thank you.
Is also an expert in constitutional identity because his doctoral thesis, his PhD candidate in Humboldt University of Berlin, Germany, and his thesis is on national constitutional identity in the European Union. So I think the presentation will also concern the European Union questions of constitutional identity. Please, Jakub, the floor is yours.
Thank you so much. Dear participants, dear guests and colleagues, good morning to, or good afternoon to all of you, and sincere thanks to the organizational aspects of this very thought-provoking and rich conference. So my presentation today is titled "The End of Claims of National Constitutional Identity Within the Multi-Leveled Fundamental Rights Protection in the EU." In contrast to more general observations as to national constitutional identity, my contribution aims to explore and accommodate a very concrete set of claims of national constitutional identity from a very specific angle, namely fundamental rights identity claims within the multi-leveled fundamental rights protection. But before I go into the media res, two terminological remarks should be stressed out. First, fundamental rights identity claims in this context are only identity claims which are based on or derived out of the common and shared fundamental rights within the multi-leveled fundamental rights protection. And second, the latter refers to the fundamental rights protection as overlappingly guaranteed by the national constitutions, the European Charter of Fundamental Rights, and the European Convention on Human Rights in accord. So, as to the structure, the presentation here addresses the following four research questions. First, is there a specific reason to examine fundamental rights identity claims separately and due to its own set of criteria? What is that reason? Second, what is the significance of multi-leveled fundamental rights protection in relation to identity claims? Third, what is the function of fundamental rights identity claims considering the special nature of multi-leveled and intertwined fundamental rights protection? Do identity claims help to accommodate the divergences resulting out of different standards and scope of protection? Or do they rather lose its legitimacy when they are being raised against the EU, since the mentioned multi-level legal orders generally share the same fundamental rights commitments? And finally, recently one could observe a radically new approach in relation to European fundamental rights because the German Federal Constitutional Court has started to directly apply and interpret the Charter. What does this turn say about fundamental rights identity claims? Can we conclude that with this changed paradigm, which is by no means unproblematic for many other reasons that I cannot go into it now, but can we claim that fundamental rights identity claims fully lost its legitimacy and persuasiveness in this scope? In other words, does the described development above signals the end of identity claims within the multi-leveled fundamental rights protection in the EU? So, as to the first question, why should we examine the type of identity claims separately? While many perhaps would intuitively examine the protection of national fundamental rights standards as essentially different phenomena as compared to national constitutional identity, the case law within the European Union indicates otherwise. A great majority of cases where the member states are arguing for a protection of their constitutional identity comes down to a specific fundamental right or an idiosyncratic interpretation of a national fundamental right, which establishes a different standard of protection. Think, for example, of the following identity claims. Germany argued that the principle of dignity in Germany, differently as in other member states who are equally committed to the same principle, prohibits the laser games where the participants simulate killing one another, as you know, Omega decision. Moreover, Austria argued that the principle of equality and republicanism prohibits the recognition of nobility titles, signed Wittgenstein, as you probably know. And Italy argued that the statute of limitation in criminal law forms part of the material law, which as a consequence means that any retroactive interference of the statute of limitations violates the principle of nulla poena sine lege previa in the so-called Taricco II decision. In all those cases, the member states argued violation of constitutional identity, but after a closer look, in fact, demanded that European law, in accordance with the European fundamental rights, should not override the national standards of interpretation of commonly shared fundamental rights. Henceforth, in practice, the identity issues often are intertwined with the fundamental rights standards as understood in national constitutional confines, or at least they argue so. Consequently, one should critically approach the underlying assumption. That is, that national standards of fundamental rights application should be respected also when a member state implements a fully harmonized EU law, which ought to be in accordance with the standards of European fundamental rights due to the Charter. Can a specific interpretation of fundamental right, which is in general, but perhaps with slightly different interpretation, guaranteed also by the Union, claim to be a matter of national constitutional identity? The answer to this question is not unambiguous, but let us firstly explore then the nature and the interconnectedness between the national and supranational legal orders addressed in our second research question. What is the significance of multi-leveled fundamental rights protection in relation to identity claims? So concerning the multi-leveled fundamental rights protection, I would like to make 3 points. First, what is the source and the scope of EU fundamental rights? Second, what are the standards of fundamental rights application due to the Charter in the light of Meloni decision? And finally, what the current constitutional design consequently leads to. As to the first point, the EU fundamental rights should not be understood only from a very positivistic point of view. The very development of the fundamental rights protection, triggered mostly by, as you well know, German Solange jurisprudence, precedes the Charter. The very source of fundamental rights in the Union was initially construed as part of the autonomous EU general principles of law. In that respect, you can see the Knoll decision, which I quote further. In safeguarding these rights, the court is bound to draw inspiration from constitutional traditions common to the member states, and it cannot therefore uphold the measures which are incompatible with fundamental rights recognized and protected by the constitutions of those states. Similarly, international treaties for the protection of human rights on which the member states have collaborated or of which they are signatories can supply guidelines which should be followed within the framework of community law, end of quote. In other words, even before the Charter was formally being effectively binding, the EU committed itself to safeguard fundamental rights in the light of common constitutional traditions. So to conclude my first point along the lines of the Solange jurisprudence, demanding a comparable, an equivalent, but not the same, identical fundamental rights protection, the Union had focused on convergent and shared standards without paying too much attention to the circumstances of divergences. So as to the second point, regarding the Union standards of protection, the above described evolvement found its place in Article 53 of the Charter, stating the following, and I quote, nothing in this charter shall be interpreted as restricting or adversely affecting human rights and fundamental freedoms as recognized by the charter, as recognized by union law and international law and by international agreements, including the European Convention of Human Rights and Fundamental Freedoms, and by member states' constitutions, end of quote. The charter therefore has to be interpreted in a way that it does not lower, modify, or upset the standards established according to several different sources. Since all the mentioned sources of human rights and fundamental freedoms do not have the same standard of interpretation, the obvious question follows. How can interpretation of the Charter remain loyal to all of the cited various sources without necessarily infringing and modifying at least some of the standards of application in practice? The formulation of the Article 53 of the Charter thus resembles an alchemist-like endeavor to put together quite different ingredients and to pursue their transformation into the same substance. The norm therefore had to be desperately judicially interpreted to obtain an understandable and clear meaning. However, the common anticipated interpretation, which would reassure the minimum level of protection according to the Charter as a safety net, but allow the member states to provide higher and more comprehensive protection, was not adopted. The Court of Justice took another road. The question has been addressed in the famous Meloni decision, where the Court of Justice essentially decided that when the EU law is fully harmonized, the Charter offers a full fundamental rights protection, which excludes any other national standards of protection. So coming to my last point regarding the consequences of this multi-level fundamental rights protection, the cited jurisprudence has unavoidably created tensions between the national and supranational standards. The EU provides for an equivalent fundamental rights protection, but not the same as guaranteed in the member states, and that creates constitutional divergences. The following question thus remain. Can these divergences sometimes legitimately be called constitutional identities? Moreover, in the light of the constant and necessary evolvement of the constitutional interpretations, can solely an interpretation be perceived as a matter of identity, a subject matter which intuitively signals something static, unchangeable, and essential? Or do identity claims have another role in this multi-leveled system of protection? Henceforth, my third question. What is the function of fundamental rights identity claims in the multi-leveled legal orders? If one disregards the true meaning of the word identity and focuses more to the undertook function, legal function that constitutional identity argument often assumes, one can explore the functional aspect of identity claims. Considering the described multi-leveled arena, can and should identity claims perhaps mediate the unavoidable constitutional divergences in the light of the tendencies to increasingly unify the fundamental rights standards? In other words, can constitutional identity claims play a role of the margin of appreciation doctrine when the EU law is fully harmonized, but the underlying fundamental rights standards among the member state and the Union considerably differ? To answer this question exceeds the scope and capabilities of this contribution. Nevertheless, two following considerations might helpfully illuminate the issue. First, can just any constitutional interpretation of fundamental rights adopt the qualifying standard of constitutional identity? That can hardly be a persuasive approach. Identity signals an essential feature which is so deeply entrenched that it cannot be simply disregarded and forcefully changed. But constitutional interpretations are time contingent in nature. Different compositions of constitutional tribunals might overturn the previous judgments, and different times with different challenges demand different ponderations of conflicting rights and thus different conclusions. So what conditions would then have to be fulfilled in order to justify the resistance against different constitutional standards? How can one argue that a particular constitutional interpretation unequivocally follows from the objectively cultural, historical, or national self-perception of the community as identified and eventually articulated by a specific group of judges in one historical moment. And my second point, even if the concept of identity would take over the role of mediating the differences among the national and supranational, how would one be able to avoid misuses and abuses of the identity argument of a member state against the EU law? Both considerations should not be taken lightly, especially in the light of the contemporary challenges within the Union to exhibit loyal cooperation and being dedicated to the common values and protect the principle of democracy and the rule of law from within. And finally, does the new development of German Federal Constitutional Court directly applying the Charter signals the end of fundamental rights identity claims? In November 2019, the German Federal Constitutional Court issued two decisions on the same day, the so-called right to be forgotten 1 and right to be forgotten 2. Both decisions of the First Senate are, in my opinion, considerably changing how the fundamental rights protection within the EU is operationalized and carried out. Moreover, the new development seriously challenges the legitimacy of the potential identity claims as derived out of or based on the national standards of fundamental rights protection. So due to the lack of time and space here, I'll focus only on the second decision, the right to be forgotten 2, which in contrast to the first decision relating to the directives or framework decisions with the leeway of national implementing solutions, addresses the fundamental rights application in the fully harmonized European legislation. So in a nutshell, the German Federal Constitutional Court decided that in the case of constitutional complaint, which relates to fully harmonized EU legislation, concretely the GDPR, it will from now on directly scrutinize and apply the fundamental rights pursuant to the Charter. The argumentation builds on the previously developed jurisprudence, which accepts that the EU provides an equivalent, but not the same fundamental rights protection as the member states. So the court stated, and I quote, "It cannot be assumed that the Charter, insofar as uniform fundamental rights protection is to apply in all member states to fully harmonized EU law, corresponds with the basic law," that's the German constitutional law, "and is congruent with its guarantees in all details." And further on, "An interpretation of fully harmonized EU law in the light of fundamental rights of the basic law would thus run the risk of prematurely applying to EU law the standards developed domestically. This would then imply that these standards would also have to apply to all the other member states." End of quote. So there are many controversial and disputed consequences of these two decisions that I cannot go into details here, but the main point of this contribution concerns the identity claims. If, due to the right to be forgotten 1, the member states are free to apply their own constitutional standards of protection in the non-fully harmonized EU legislation, and the member states directly apply the Charter in the fully harmonized areas of the EU law pursuant to the right to be forgotten 2, there's no need and reason anymore to raise a claim of national constitutional identity. In the first scenario, the member states can freely apply their own standards. Henceforth, they are free to give effect to their constitutional interpretations, which also claim to be perhaps their constitutional identity. And in the second scenario, the member states openly accept that in the fully harmonized EU legislation, they no longer use their constitutions as the yardstick of constitutionality, and thereby no longer raise their constitutional identity. So while deciding to directly apply the Charter, the national constitutions remain outside of the scope of application. So that's my last slide, and I'm concluding. Identity claims are covering a wide variety of issues, from ethnocultural elements, historical claims, and protection of constitutional and national traditions, but also the principles of democracy, the rule of law, and the protection of fundamental rights. When examining national constitutional identity claims in the European Union, they mostly have the role of accommodating the relationship between the harmonizational pursuit of the Union on the one hand and protection of national peculiarities, sensibilities, and diversities on the other. However, when we are talking about the national constitutional identity claims, which are arguing for disapplication of EU law in the name of identity, but are itself based on or derived out of the common and shared fundamental rights, I argue here, a different evaluative approach should be adopted. Additional questions concerns the potential role of identity claims in the multi-level fundamental rights protection. Can the identity claims constructively take the place of accommodating the minor differences in the light of shared and common basic constitutional commitments through the dialogue with the Court of Justice of the European Union? Or shall that function be rather attributed to another mechanism, less problematic in its normative and descriptive understanding? And finally, a new development of the German constitutional jurisprudence, if followed by other member states, signals a potential change of paradigm in relation to identity claims. In that light, one can argue that fundamental rights identity claims no longer enjoy the legitimacy should the member states follow the German approach and apply their own constitutional standards in not fully harmonized EU legislation, but directly apply and interpret the Charter in the fully harmonized areas. Thank you so much for your attention.
Thank you, Jakob. Very impressive presentation. We very much appreciated your PPT. They were very, very informative and very picturesque, I would say, but well, very bright. And thank you all the speakers for your very valuable contribution to our common roundtable discussions. I do hope that all that interesting presentations will raise the questions in the auditorium. So please ask questions if you want through the chat, or just raising your hand, or switching on your mic and voicing your question. Please, who would like to ask a question? Yes, Wojciech, please.
Thank you. So, can you hear me?
Yes, yes.
So I have a question or sort of comment to my colleague from University of Warsaw, to Mr. Maximilian Hau. And, you know, a frivolous response to an invitation to compare or choose between margin of appreciation and constitutional identity would be to say that's a little bit like choice between cholera and COVID-19. No, none is particularly palatable and pleasant, even though each of them may have initially a noble pedigree and rationale. We know that if we look at it functionally, both are used by rogue states, rogue governments, which would like to keep on breaking the rule of law, individual rights, and principles of constitutionalism without European oversight, either within the Council of Europe or within the European Union. But my interest is less sort of frivolous, and it is, but why would, it's more perhaps methodological. Why would anyone feel that one has to choose between these two doctrines? Even though functionally, as I said, they come to more or less the same, nevertheless, they originate from completely different structures. Margin of appreciation from Council of Europe, national identity, connected to the doctrinal concept of constitutional pluralism from the EU. And I think we cannot even start comparing these two doctrines without realizing that these are organizations based on completely different constitutional structures, because the Council of Europe has nothing comparable to the principle of direct effect and supremacy as the EU. And so integration, legal integration, constitutional integration within the Council of Europe is much weaker and much more shallow than within the EU. And that may explain perhaps something that I think you have alluded to without necessarily saying it expressly. So let me paraphrase what I have read to be your main point, that margin of appreciation is somehow a safer doctrine, a less intrusive, a less dangerous than constitutional identity, and that is why you choose it. But I think that is precisely because with Council of Europe is quote unquote safer for rogue states. There's only so much that the European Code of Human Rights can do to dictate common values. So member states can tolerate, can live with this safe and weak concept of margin of appreciation, while constitutional identity, of course, being a concept claimed by the states rather than granted by the court, as is the case of marginal appreciation, obviously is a much stronger defense, much thicker shield for rogue states such as Poland and Hungary. And therefore, in a polity which has much deeper and more direct level of integration, functionally, it is needed to protect the states which, as we know, if they applied to the European Union today, they wouldn't have been admitted under the Copenhagen criteria to which Mr. Popławski alluded. Thank you.
Thank you. I think we will pick up all the questions and then we'll let the speakers to answer them all. I see a raised hand of Celine. Celine, please take the floor.
Thank you very much. My question goes to Tatiana. Actually, I really enjoyed your presentation because the Russian Constitutional Court's decision you explained us is one of the interesting decisions. How a constitutional court can fail, to execute one of its primary functions, let me say. So in order to understand the court's attitude, I would like to ask you whether this decision ruling was made unanimously, or is there any dissenting votes? If there is any dissenting vote, what is their, or what are their reasonings to contend or to contest the majority ruling? Thank you.
Thank you, Celine. I also see a raised hand of Maximilian. Please ask your question.
Yes, thank you. I have a question to the third team of speaker. I would like to say thank you for reminding me this. Firstly, this is the reader book, which I read quite a long time ago. And I have a question. It's a methodological question. Why you chose this? Why you chose to use this notion of aporia, and however understood within the philosophy of the reader, or just this within this ancient meaning of Greek philosophy? Because I think that the struggle between the national level of, let's say, identity, etc., and this multinational system is actually, for me, not quite an aporia struggle, because from my perspective, I think so. After all, there are questions to this struggle. There you may answer this struggle, for example, most obvious by making just the political decision that, for example, we will integrate deeper, and then we will, of course, let's say, lose some of the constitutional identity as I think you define it, or otherwise we will make a political decision that we will stick to our identity, which will have a consequence that will weaken our integration processes. So my question is how you use this this notion of aporia, and how you would respond to this kind of political, hardcore political approach? Thank you.
Thank you so much for your question. So, Tatiana, please take one more question from chat. It's written there. And are there any questions now? Yes, Helle, please ask your.
Thank you so much, Sergei. I really want to congratulate this panel. I've actually been attending all I think all the panels at the conference. It's been a wonderful conference, but I simply have to say I found this panel really fantastic. I think it's a very, very high quality of papers, and I'm sorry that we don't have time. I can't address all the speakers, so I would like to. So I just have a follow-up question, I guess you could say, to Celine's question to Tatiana Kramova. Thank you so much. This was very, very interesting. Your deep analysis of the argumentation of the Constitutional Court. Could you just say a few more words on when this evolutive interpretation style was first applied, and maybe also, does this have any basis, this particular interpretation style in Russian theory on interpretation? I found this really, really interesting. And then a question for the two speakers, Alberto Nicotini, I think, and Emile Martini. Thank you very much. This was also a very interesting presentation, and you emphasized this judicial dialogue, and which is of course very important between the national courts and the EU court. So my question to you would be, how do we handle, because in some member states, the courts simply do not play the same role as they do in other member states. In some member states, you have very active, for instance, in Germany, a very active constitutional courts. What should we do about this dialogue, this, you call it judicial dialogue, as regards to member states where courts play sort of a more reluctant role, for instance, in the Nordic countries where I come from? Thank you so much.
Thank you so much. Did we pick up all questions? I do not see any more. No more raised. Oh, Jakob, please ask yours.
Yeah, thank you so much. I also just have the comment for the colleagues from Antwerp. So I just wanted to refer to an article which I recently read, and it's really recent, written by 4 constitutional judges from Germany, Austria, I think Lithuania and Slovenia. The title of the article is "The Role of the Constitutional Courts in the European Judicial Network." So, and basically in this article, the 4 constitutional judges are kind of appallingly suggesting that this judicial dialogue, to the preliminary reference, should actually also function from the other way around. So actually that the Court of Justice of the European Union should ask the national apex courts to clear up the issues, what somehow you're also suggesting in your presentation. Anyhow, I see so many problems with this suggestion, like power grabbing and, you know, some kind of trying to redefine the balance between the Court of Justice of the European Union and 27 actually other member states. So in a way, I think it's a very bold proposition, but also very dangerous one. So I just want to say, if you know this article and if you want to comment on this, but also from my side, great contributions from all of you. Thank you so much.
Thank you for your questions. I think we have all of them. Now let the speakers answer, I think in the same order as you made your presentation. So Maximilian, please answer the question of Professor Sadursky.
Okay, I would like to say thank you, Professor Sadursky, for your question. It's actually a very difficult question, and I guess one of the most important regarding my presentation. So I will start with saying that I agree with you on what you said generally about the relation of marginal appreciation and constitutional identity. And I will respond to your question why I chose to compare those instruments. So I think that there are at least 2 answers to the question. One is like more general. I think that I agree that, of course, that the margin of appreciation is a Council of Europe, and it's much safer instrument. It was my point to emphasize it. And I see, of course, that the constitutional identity is a concept from another word, EU word. But I think that after all, constitutional identity is nowadays also a concept which lies on the table of constitutional theory. And I just think that it might be used, even though there are differences between the concepts and within the environment in which they were born. But I think that the more important answer is the second one. And as it can be found, I think, in the literature, some ways when the margin of appreciation was used by the state and was framed by the state, like in SAS judgment, was so close to what I think is one of the most dangerous way of using constitutional identity, because there were cases where the state said something like, the state presented some vague concept like this, living together, and say, this is our core, and we cannot go further. This is what our last word on some topics. And even though it was expressed in margin of appreciation construction, I think that this is kind of transgression, this kind of reasoning. And this reasoning, I find more similar, more close to constitutional identity reasoning than margin of appreciation reasoning. So that's why I chose to compare those two concepts. Thank you.
Thank you so much. Tatiana?
Yes, thank you so much to the audience, for the speakers, for the wonderful presentations. I've also picked up a lot of issues for further research, and thank you for the questions. And I think all the three questions that I got are really interconnected. So some of the answers will be really quick. There were no dissenting opinions on this very controversial judgment. And well, the style generally of adopting the judgments of the Constitutional Court is that we, of course, due to the secrecy of deliberation, we don't know how the debate went within the judges. The only thing we know is that one judge did not participate in the adopting of this decision, not because he voted against, but because he just did not participate. The judgment was delivered in 2 days, so the amendments were adopted on the 14th of March, and on the 16th of March of 2020, we had a 52 pages long judgment approving every single amendment as compatible with chapters 1, 2, and 9, with no dissenting opinions. Maybe another quick note on the side is that the whole constitutional amendment process triggered a reform of the Constitutional Court, and a part of it was enshrined in the Constitution. For example, the powers of the court were redefined slightly, and the court was given additional powers. But also a lot of other amendments to the functioning, to the organization of the court were added in November 2020, and among them was the norm, the provision that we now have, that no dissenting opinion of the judges of the Constitutional Court are to be made public. So the justices may adopt, as of November 2020, dissenting opinions, may write them actually, but will never, or at least for a long time ahead, we won't know their contents. So this is the first thing. The second question is when the evolutive interpretation of constitutional principles appeared in the court's practice. Well, it's an interesting question because the court never says explicitly that it is applying this type of reasoning, this method of interpretation. But we may see probably in the 1990s, the court, if we think about, reflect on it, it allowed itself this weak change, gradual movement in the interpretation of many fundamental principles, mainly in the realm of using the power of interpreting the constitution, because the Constitutional Court of Russia has a separate power to interpret the constitution. And since the end of 1990s, we had only one case of such interpretation, and it was very specific. But in the 1990s, there were a lot of appeals to the Constitutional Court from other branches of power to give the interpretation of the Constitution, and that's how Constitution got its fuller content of the principles. And a strong change, and I mentioned that briefly in the slides, we saw a very notable case of strong change in 2005 in another famous ruling of the Constitutional Court on a prohibition of elections of regional governors. And that was, at least by the majority of the scholars, assumed to be a contradiction to the previous position of the Constitutional Court when it defined the rights prescribed in the Constitution as allowing the citizens to elect governors, while in 2005, the court took back this position and said that no, the Constitution doesn't explicitly say that, and therefore there is no such right. So this was an example of a regressive interpretation, and we may see some other examples of some aspects of interpretation in the court's practice. And this probably brings me to the chat question. Is it possible for the Constitutional Court to avoid politics? Well, in this judgment in 2005, there were some separate opinions of the Constitutional Court. So there was more debate, let's say, around this judgment. In 2020, no dissenting opinions. Maybe this is one of the answers to this question. A more direct answer is, of course, it's a very difficult, in my opinion, position that the court has in accordance to the whole idea of separation of powers and the role of the Constitutional Court in this process. But that's why I believe it's so important to assess and to develop the methodology of the court's argumentation and interpretation of the principles. And as the court, in my opinion, does not devote much attention to and does not really explain itself in such a way that lawyers reading this judgment understand this methodology, the decisions may become or may look more political than legal, I'm afraid. So again, if the court was more specific or more coherent, maybe in its argumentation, we would have more reasons to assume that the judgments are less political and more legal. That's probably my brief remarks. And thank you again for the questions.
Thank you so much. Alberto and Emil, it's up to you to decide who will.
Yes, yeah.
Yeah,
so
please.
thank you for all the question. Really very interesting. So the first question is from Maximilian. Yeah, I think here there are two layers in general, right? There is a layer more theoretical, theoretical legal layer, and more political layer. I think that in general, if we just set aside the political one, the notion of a European identity, we chose the Derrida as a theoretical framework because it is indeed, we really think it has an aporetic dimension, the European identity. Yeah, I mean, it's really not a case that the European Union construction started in a more postmodernist environment. From a theoretical point of view, there is no supremacy clause as would be in a modern construction like in the US, etc. So I think that's why Derrida comes to question. But also the political point of view, I think it's, I'm not very much convinced that, for instance, Hungary and Poland, let's say, questions about European identity and invoking the European clause has a legal base. I think it's not part of the Polish or Hungarian constitutional identity invoking a national identity in the way in which the governments do right now. And that leads me to Jacob's question. I did not know the article you mentioned, but I think it's by giving the possibility not to the government, but to the courts to interpret the constitution and say why there is another understanding, a competing understanding of the rule of law, of democracy, etc. And by making these arguments explicit, it is possible to really have a constitutional dialogue. The thing is just make the motivations and the arguments explicit. Of course, it will be the courts to judge in the end. That's why I think it's interesting, the American model of the certified question, because it's optional. So the federal court has the option to ask a question. And even when the question is asked, it has the option to follow the state advice. As for Professor Klunke's question, active or less active courts, indeed, I think there are. It's not a matter only of judicial dialogue, but constitutional dialogue more in general. There are some instruments that are at the disposal of the European Court of Justice to ask for opinion not only to national courts, but also to bodies. So if there are, like in Nordic countries, a parliamentary committee that check the constitutional, let's say they carry out a sort of constitutional review of legislation, those entities and bodies could be consulted to, again, just to make the argument explicit without prejudice of the European Court of Justice prerogatives. I don't know if Emil has something more to add.
Maybe I would like to just add something to answer to Jacobs on the possibility to have this sort of reverse question between courts. As you also mentioned, for example, the Tarico case, I think it could really help to have this possibility to have a reverse question, as sometimes the kind of attempt of dialogue that there is between constitutional courts and the ECJ is sometimes more a sort of putting two monologues together, as sometimes the Court of Justice is trying to interpret itself what's the core constitutional principle of a member state, instead of having also the opportunity to let, for example, a constitutional court express what is the core principle of its own constitution. So maybe to institutionalize this kind of dialogue would really help to have more a dialogue than two monologues in this sense, even though there are some difficulties, because also the ECJ wants to be sort of wants to have the last word on everything. But I think that this kind of institutionalized reversed question would not lead the supremacy of the ECJ in the overall interpretation of the European Union law, because the important thing is to give the court the possibility to really hear the voice of the constitutional courts on some core national issues. And it's this way I think that the article you mentioned could give some good ideas in this sense. Thank you.
Thank you, Emil. So there were no direct questions, if I didn't miss anything, to Carol and Jakob, but Jakob wanted to add something to Professor Sadurski's question. Please, Jakob, take the floor.
Yeah, thank you so much. Professor Sadurski, if I may just add something to your question, which was not directed to me, but if one forgets for a second that we're talking about the RAC states and that we're talking about abuses, but just think about the conceptual framework, whether we want to have within the European Union law and within the European Union, whether we want to have the same fundamental rights standards and the same interpretation in the light of the fact that the European Union's legislation is more and more encompassing, and we have more and more fully harmonized EU law. So there's clearly a tension between this ongoing process of more and more fully harmonized EU legislation on the one hand, and on the other hand, the factual circumstances that different member states understand the same principles slightly different. So in that light, I asked the question, do we need a tool to accommodate those differences? Do we just need to pursue to have a unified fundamental rights when it comes to the scope of EU law? And in that sense, I understand the contribution of the colleague Hao very enriching, because in a way, the principle of the identity issue is not kind of assuming this role. And I think it brings with itself so many obstacles, it brings more problems than it is able to solve, in my opinion. But when compared to the margin of appreciation, perhaps, the margin of appreciation, not that we should have the margin of appreciation in the European Union, we don't have it. But if we need a tool, then perhaps margin of appreciation comes closer. And I agree with the colleague's presentation in that sense, because it doesn't assume something that it's not going to change. It doesn't. In the legal case, for example, I will be very short, but I just want to say in the legal case, for example, while kind of declaring this certain issue, constitutional issue as constitutional identity, it then disabled the legislative power to kind of adopt this legislation and to move along in the light of the other states, and to kind of come closer to the kind of common solution within the European Union. In other words, declaring something as identity may then be an obstacle, because it freezes the issue rather than it kind of embraces the convergence. So in that sense, I think the margin of appreciation has some kind of has a better potential in this sense, not one-to-one, not as a transplant one-to-one, but just as a comment from my side. Thank you so much.
Thank you, Jakob. So, Carol, do you want to add something to the answers, kind of remarks?
Thank you. I think no, but I was just considering this concept of the margin of appreciation. So I would be it would be interesting to hear the potential answer of the Professor Sadurski. But I would like to add also that in fact there was some examples, especially in the literature of the European Union law, concerning the potential methodological correctnesses of the margin of appreciation. However, also in the EU law, however, I have to add that it's essential of the margin of appreciation is at least some part of community, in fact. So that is the reason why I also see the potential difficulties, methodological difficulties, because they need to have a certain common core of such institution, of such principle. So according to the rest, I'd like once again to thank everyone, because last 3 days make me full of new ideas. So thank you very much.
Thank you. So thank you all for your contributions to our session. It was very interesting presentations and a very interesting discussion. Thank you all, and hope you will stay with us for our next, actually the last session of the whole roundtable, as well as the closing ceremony today. And we will finish, and as we planned before, it is a little bit before the time schedule, and thank you for this from our entrepreneurs. Thank you, and stay with us.
Thank you.
Thank you.
Thank you.
Good afternoon, Lilian. I can hear you. I just wanted to make sure that I pronounce your name correctly. So it's Lorian Alessard? Yes, thank you. And there's Francesco also. Good to see you. Also, good to see you.
Thank you. Good to see you.
Good to see you.
Thank you. Good to see you.
Good to see you. So Francesco, if I may ask you, there's two authors to the paper you will present, right? So are you going to present it yourself, or will you be two presenters?
Okay. At the moment, there is like something like
at the moment
echo.
there is like something like
at the moment
there is like something
maybe.
like
In any case, we will.
Okay, I think you need to maybe log out and log in again in order to make sure that the, yeah, please try that.
Yes, sorry, I didn't realize this time. Do you hear me? Yes, thank you.
Okay, Francesco, maybe we try again and see if your microphone works better now.
Okay. Maybe is it working?
It's working, thank you.
So to answer the question, we will do two interventions in one, if possible.
Perfect, very good. So it is now time, I do believe, to start this last session of the roundtable. I just want to get a clear go-ahead sign from Sergey, Professor Bielov, and maybe Anna Gritsenko before we start. Are we ready to go?
Yes, we are ready. We wanted to remind to all the participants that we have translation from English to Russian and to French. So the French channel is available, and please, those who want to listen or to speak in French, please feel free with this.
Perfect.
No more introducing remark. Please, I'm gonna take the floor.
Okay, thank you so much, Sergey. Well, good afternoon, everyone, and welcome to this last session of the roundtable. It's my great pleasure to chair this session. We have 6 papers and 8 speakers, if I'm informed correctly. And the speakers will present in the order given in the program, and they will speak for approximately 10 minutes per paper. And then we will end with a Q&A session for approximately 10 minutes or whatever time is left, I guess. I'm looking forward to this very much. And I want to just jump right into it and give the floor to our first speaker. It's Lauriane Alessard, who is a PhD in public law and a lecturer at the School of Law of Clermont-Ferrand in France. So please go ahead, the floor is yours.
Thank you, Professor. I will try to share my PowerPoint. I don't know if it's okay for you. Okay, thank you very much. First of all, I would like to thank you very much, the organizers, for giving me the opportunity to present my research at this great event. Of course, I wish that the conference could have taken place in St. Petersburg instead of being online, but I'm delighted to participate. I would like to share some hypotheses I defended in my PhD thesis dedicated to the constitutional analysis of identity. I will present the main idea.
Excuse me, Lauriane.
Yes.
May I kindly ask you to fix somehow your sound? It's not clear enough, and it is very difficult for interpreters.
Okay, thank you. I don't know why.
The sound is not clear. Maybe you use some other mic.
Sorry. 2 seconds, please. Maybe with that could be better. Yes. Sorry. Thank you. It's okay. It's better.
Yeah, it's better.
Yeah. Thank you.
Thank you so much.
I would like to. I will present the main ideas, and I will PhD thesis, and I will remain at the disposal for further details, or if you'd like to have access to my thesis.
I'm sorry. It's again very difficult to understand.
Yes.
It's like it's a filter or something on your microphone.
Maybe you want to close if it is your background. If it is virtual. Is it virtual background? You may want to close that virtual background.
Yes.
It takes a lot of space.
Yes.
And lower down your video HD.
Okay.
So a lower quality with the video.
Okay.
I'm afraid it's not because of video.
That it's not because of that. Yeah.
Yes, it's better.
No.
It's not. Okay.
So, Lauriane, I'm thinking maybe if you want to log out and log in again, or should we try that, Sergey? Is that a good solution? And maybe let someone.
I'm not sure. Maybe you have some headphones with mic. which could be used for this? No?
No. It's not my connection.
I think it's something with your microphone. It's
yeah,
clear, the sound. Lorian, I'm very sorry. May I ask you to maybe log out of Zoom and try to log in again and close down all the systems you might have ongoing that you don't need? And I suggest that you do that, take your time and try to figure it out how it works, and we move on to the next paper. In the meanwhile, then we come back to you.
Yes.
You okay with that?
Okay, thank you.
Yes, okay, let's try that. Let's try that.
Thank you.
Okay, I'm sorry about that. We will try to manage as we go along. And then Francesco and Federico, are you comfortable making your presentation now? That's perfect. Thank you for being flexible. Then I invite Francesco Cirillo, PhD candidate in law and cognitive neuroscience at the Faculty of Law at the Telematic University of Rome, Niccolò Cusano, together with his colleague Federico Girelli, Associate Professor in Constitutional Law at the same university, to give your presentation. I understand you will be two speakers, and you have 10 minutes. So please go ahead, the floor is yours.
Thank you very much, President Professor. And I'm very happy and honored to speak in this roundtable. My talk and that one of Professor Girelli will focus on the relationship of technological innovation with a constitutional identity. And according to the business theory, disruptive innovation is an innovation that creates new market and value network. The term was first defined and analyzed by Christensen in 1995, who described revolutionary innovation as discontinuous, sustaining innovation. These innovations characterize the emerging technologies, also defined by the acronym NBIC technology: nanotechnology, biotechnology, information technology, cognitive science. More generally, technological growth could include incremental developments and disruptive technologies. For example, we can refer to incremental developments every time a DVD replaces a compact disc. Still, we would say that a process of disruptive innovation is underway when a type of technology completely replaces the previous type, creating new values and markets, intervening with a quantitative and qualitative modification of the context. The car that replaced the carriage is a disruptive process. Similar processes in history were always exceptional and often, if not always, brought significant social, political, and finally, legal changes. Suffice it to refer to the invention of printing in the genesis of modern societies, modern politics, and of the law modern state indeed, on which we cannot dwell now. Some might observe that innovation is a constant in history, and that is a distinctive feature of modern societies. Indeed, innovation has its centrality in many economic theories, starting with business cycles of Joseph Schumpeter, the economist who popularized the term creative destruction, coined by the sociologist Werner Sombart. However, in the current framework of emerging technologies, the speed of disruptive innovation is very high. The quantitative dimension of the phenomenon changes the landscape day by day. And the technological and economic context, which always influenced the society, politics, and law, is changing rapidly with a new speed never observed in human history. And what happens to the law? Meanwhile, far from supporting this continuous redefinition of values, the law promises to react by maintaining its own identity through changes. Here comes the issue, also the issue of constitutional identity. What is constitutional identity, or what can it be? There is no general definition of this concept, nor a shared belief on its use in constitutional law and in constitutional comparative law. What is sure and generally shared by several authors, for instance by Rosenfeld, is that the place of function and the function of constitutional identity is determined by the need for a dialectical mediation of existing, evolving, and projected conflicts and tensions between identity and difference. And therefore, the relevance of the relationship among the constitutional charts, the constitutional systems, and their context. Suppose then constitutional identity is the relationship between the rules and the context that produces and imposes these rules. In that case, the process of technological innovation and the context of disruptive innovation also have an impact on constitutional identity. And in this landscape in which innovation changed the world day by day, technology breaks into law, but it's not so easy to understand its contribution, whether it is a positive or a negative agent. If we think of the case of information technology, this assumption seems quite evident. During the first season of the internet, many people believed that technology could create a new space for free and equal web citizen, new tools for participatory democracy, or even direct democracy, a strengthening of the right to information, and so on. Information technology would have had a disruptive force, but above all, it would have deployed a positive force by strengthening some elements of the constitutional identity of modern societies. That is, the values, for instance, affirmed by democracy and liberalism. What the French and Russian Revolution had not done, computers and the internet would have done, building an artificial space dominated by an Enlightenment rationality. In this perspective, the impact of information technology on constitutional law should have strengthened a specific identity at the expense of nationalism, inequality, social injustice, or censorship. Just 20 years ago, such enthusiasm seemed rather obvious. Today, not even the most optimistic scholar could look at the world of information technology with such a naive gaze. It is now clear to everyone that this boundless and unregulated digital space, far from representing the Eden of the reason, somewhat resembled the Far West. Together with its positive contribution, information technology increases inequalities, creates information bubbles, and erodes state sovereignty. It affects fiscal, judicial sovereignty, and obviously political representation. The impact of the disruptive process of information technology on constitutional identity is so ambiguous that we can still ask ourselves, after decades of research, will the internet be the home of democracy or its grave? More generally, can constitutional identity, which inspired to fix a set of absolute values, whatever it means, coexist with a context of constant change? The problem, as we can already see, is not just science fiction. And I now leave the floor to my teacher, Professor Girelli, who will investigate the remote vote of parliamentarians about a specific case in the health emergency. Thank you very much.
Thanks, Francesco. Thanks, Anna, and thanks to all of you. I'm very happy to be here today. New technologies played a leading role in the health emergency that we are still experiencing, and they affected the very functioning of democracy. In Italy, questions have been raised about the feasibility of remote voting for the deliberations of parliamentary assemblies to counter the spread of infection and thus ensure the continuity of parliament operations. I will say it immediately. I do not find convincing the feasibility of remote voting for parliamentary assemblies, even though reliable opinions have been expressed in this sense. Meanwhile, for a positive law reason, Article 64 of the Constitution and the numerous provisions of parliamentary regulations undoubtedly refer to the physical presence of deputies and senators. Furthermore, we also admit that we already have today the technical knowledge to guarantee personality, secrecy, freedom of vote, even at a distance. The very high professionalism of the technical administrative apparatuses of the chambers is known, just as it's known that they can have substantial economic resources. Professionalism and resources are undoubtedly the ideal prerequisites for an excellent operating result. But not everything technically possible is also appropriate to achieve. The progress of medical science testifies to this every day. As far as we are concerned, we could speak of the need for a parliamentary bylaw due to the choices on the work of the assemblies that politics is called upon to make in these times of pandemic. Those who know the internal activity of the chambers have underlined the need for a re-engineering of parliamentary procedures so that technologies is seriously at the service of good politics. Nonetheless, the assembly of the chamber or the Senate is not a board of directors, a courtroom, the hearing room of the Constitutional Court, much less a regional or local authority council. The efficiency of the vote and of the decision cannot be the only criterion when the exercise of political representation is at stake. If so, why keep Parliament open even in ordinary times? The institutional seat of political representation could move online to a highly advanced digital platform, a frightening outline already hoped for by some authors and thinkers. Nonetheless, the political moment is very relevant to the reflection we are carrying out. In Italy, the widespread and demagogic anti-parliamentarianism is therefore all to see, accomplishing now the condition to make Parliament work independently of the physical presence of deputies and senators, risks, even unintentionally, to fit the idea that democracy can work without parliamentary assemblies. The number of parliamentarians in Italy has just been reduced. It's not a scandal that the deputies have gone from 630 to 400, the senator from 315 to 200, and that it has finally been made clear that only 5 presidential nominated senators can sit in the Senate. What is worrying are the autocratic suggestion that we cannot deny that have accompanied this constitutional revision since its conception. The health emergency intervenes in this climate of mistrust towards Parliament, of a crisis of political representation. The idea that technology allows for the strengthening of political representation, enabling the exercise of the parliamentary mandate electronically, otherwise prevented by the material impossibility of reach the institutional seats, perhaps does not fully consider the heterogeny of the ends. It is necessary to consider the widespread feeling of intolerance towards Parliament, a feeling also due to the not excellent conduct of a political class, which is not always up to its very delicate task. The jurists, it is true, must deal with the rules, not with the climate, not with the more or less widespread sentiments. But constitutional law deals with cases in which we can't ignore the rate of politicity. With its claim to regiment political action, parliamentary law has an osmopromethean nature. It aspires almost to the impossible, to steal fire from the gods. The value of practice, the potential of nemine contradicente principle in this particular sector of the legal system are known. It is constitutional guaranteed parliamentary autonomy. In 2018, the Supreme Court of Cassation affirmed that the exercise of the parliamentary function is always and in any case inscrutable. All this is remembered certainly not to enhance the now perhaps anachronistic principle of the Interna Corporis Acta, but to highlight the full awareness that one has about the extent of the self-organizing power of the chambers, without prejudice to the fact that this substantial autonomy, is what be reiterated, does not escape. Indeed, is subject to the sovereignty of the Constitution. I think there are no obstacles to carrying out some typed activities electronically, such as cognitive ones, hearings, but there is no alternative to the assembly. The representative of the nation is not a monad. Its determination are also the fruit of that relationship which can arise within political assemblies and are consolidated thanks to the principle of freedom of the mandate, which guarantees that the action of the representatives does not find impediment. This act shall converge, hopefully, on the good of the Republic. If now the schools are open and they ensure the safety condition, it seems hard to imagine that the Chamber and Senate encounter insuperable difficulties in organizing their work and access to their offices in such a way that the health of parliamentarians and employees is preserved. From the next legislature, then the assemblies will be less crowded due to the reduction in the number of parliamentarians. A part of the debate on remote vote on remote voting, the question was also raised about the possibility of remote voting by parliamentarians with a severe disability. This topic has great importance. It deserves adequate investigation, but it goes beyond the specific problem of these days, namely the admissibility of remote voting in the chamber's deliberation with the parliamentarians who are not sitting on their seats in electronic connection due to the pandemic. The analysis of the position of the parliamentarian with disabilities must be placed in a context of ordinary work, which certainly cannot and must not neglect the specific needs of the elected person who, due to his personal condition, encounters more difficulties than others in exercising the free parliamentary mandate. Thank you. Thank you very much. I apologize, and I have to leave the meeting now because of a family commitment. I have got to go to the first communion of my granddaughter. I'm sorry, thank you very much. But Francesco remains.
That's very good. Thank you, Professor Girelli, and congratulations. And of course, we are very happy that you could spend these 20 minutes with us here today, although you have this important family event to celebrate. So all the best to you and your family and to your granddaughter.
Thank you very much.
Thank you both Girelli and Tirello for this.
Ciao Anna, ciao Sergei.
Ciao, ciao.
Bye-bye.
Ciao.
Okay, thank you, both of you, so much. Let's give it another try, shall we, Lorianne, and see if it works better now.
Thank you very much. Do you hear me? Yes, it's better. Okay, I'll try on another computer.
Now it's much better. Thank you very much.
Great, thank you. Okay, I didn't find my PowerPoint, but I think it's on my day. Okay, well, it's not very important, I think. Okay, so sorry about that, and I will present finally the main ideas that I defended in my PhD thesis, and I will remain at your disposal if for further details, or if you would like to have access to my thesis. The inclusion of identity in constitutional law is a growing phenomenon in Europe. Today, out of the 47 member of states of the Council of Europe, 22 have a constitution that explicitly refers to the word identity. Very recently, in two states, Russia and Hungary, the constitution was amended to better take into account the identity issue. More precisely, the constitutional reforms that came into force in Russia on 4th of July 2020 introduced the guarantee of Russian cultural identity, while the Hungarian constitutional revision of December 2020 added, among other things, a provision in Article 16 that defines gender identity and protects the family and education in accordance with the constitutional identity and values based on Christian culture. Identity can be present explicitly as constitutional identity, for example, or as several other forms, but mostly can be revealed by the constitutional judge. In my PhD thesis, I tried to understand the whole phenomenon, its evolution, and its effects by studying the constitutional texts of member states of the Council of Europe, as well as the constitutional case law. After analyzing more than 350 decisions, I was able to draw up a reading grid of the identity that is found within constitutional law beyond the sole word of identity. I identified 4 types of identity in the domestic constitutional law in Europe, which are divided into 2 families. Firstly, identity can be considered as existing prior to the constitutional norm. In this case, identity is a goal to recognize, defend, or to develop a specific identity, or identity is a tool to achieve something else. Democratic features with positive discrimination for some communities, for example, or taking into account of some particularities in the legislative process. Secondly, identity can be considered as existing within the constitutional norm. In this case, norms can be the reflection of an identity which exists outside of the norm. It reflects of mirrors values or pre-existing identity of the people, for example, or norms can be the origin of an identity. Constitutional identity belongs to this second category. Constitutional identity is a notion constructed by constituent power or mostly by the judge, generally to regulate the relationship between national or European legal orders. But in the same time, constitutional identity is a doctrinal concept, which essentially means the identity of certain constitutional principles, or more generally, as the identity of the Constitution. Based on this, several questions arose. Does the constitutional identity have or not links with other identities present in the same constitutional law? Do identities existing prior to constitutional law affect the identity of constitutional law in a broad sense? In my research, I tried to observe whether there were interactions between the different types of identities and to discover what was the place of constitutional identity among them. I will argue that identities are interdependent and form a system. This is the idea I will present in the first part. And secondly, the system of identities determines the constitutional principles and, as a consequence, the identity of the constitutional system itself. I will explain this in a second part. First point, the existence of a system of identities within each domestic constitutional law. In all the states, the constituent power has made a choice between substantial identities. In some cases, it chose to favor one identity upon another, but once chosen, identity is confirmed by the constitutional judges, but who sometimes goes far beyond the choice. As a consequence, appears a balancing of identities which might be different depending on its interpreters. Firstly, the selection of identities within constitutional law. Such a choice may be done either by the constituent power or the constitutional courts. A choice between several identities is made by the constituent power and introduced into the constitutional text. The challenge is to establish a common identity that brings people together sufficiently and to deal with community or individual identities that may diverge from the common identity. On this occasion, the choice can be made to inscribe an identity seen as endogenous, that is a statement of an existing identity, or on the contrary, an exogenous identity, which will have a more performative role. For example, the latest constitution adopted in Europe, the Hungarian constitution, emphasized a particular and historical collective identity claiming Christian values. It thus rejected the liberal identity it had adopted when moving away from communism in the late 80s. Sometimes the chosen collective identity excludes more precisely certain minorities or individual identities in their expression. As an example, sexual minorities in particular, in Hungary, for example, are limited in the development of their rights, especially to be recognized as a family. Second, a choice between identities is also made by the constitutional judge. The judge can seize identities in different ways. Firstly, the judge may reproduce the choice of a common identity made by the constituent power. Through its interpretation, the Constitutional Court gives a meaning to a word according to the content of identity. For example, Article R of the Fundamental Law of Hungary establishes a guideline of interpretation for the judge. Another example is a reference to the spirit of the Constitution in Estonia. Or Ireland is the best example where religious identity included in the preamble can be invoked by the judge upon judicial constitutional review. We can also refer to the eternal clauses which are binding in Germany or Turkey, for example. But all the constitutions do not enshrine such a binding guide for interpretation. In such cases, the judge is the one actor which chooses the importance to be given to an identity. For example, in a 2009 decision, the German Constitutional Court, after referring to Germany's National Socialist history, confirmed that the entire constitution should be interpreted antithetitically to that period, according to the system of values discovered by the famous Lute decision in 1958. Such a situation also arises when the judge is facing a conflict of constitutional norms. In this case, identity can influence the choice of the judge in favor of a norm because this norm wears an identity, or because the judge chooses to follow an identity which is outside of the norm. The identity could be a motivation for the judge to confirm an occasional restriction to a fundamental right. For example, in Latvia, in 2015, the Constitutional Court considered that the obligation to raise the national flag on private buildings for national days is not an unconstitutional restriction to the freedom of expression of the owner, because it protects the national identity and it is a national duty to respect it. This leads to the idea of the balancing of identities. Identities coexist in constitutional law and their cohabitation is not fixed. The constituent power, and more commonly the judge, may reverse the primacy of one identity over another. As a result, identities are like a pendulum whose balance can change. For example, in 2012, a reform of the Norwegian constitution led to the juxtaposition of the several provisions in Article 2, human rights, democracy, and the rule of law, on one side, and a new reference to our Christian and humanist heritage as a basic value on the other side. By this addition, which had a priori symbolic echo, the constituent power intended to preserve a balance between the outward-looking identity and the identity inherent to Norway, both of which permeate the constitutional text as a whole. In this way, it is left to the judge to ensure that the balance is maintained. The balance may happen between identities belonging to the same category. For example, recently, in 2019, the Latvian Constitutional Court confirmed that school education should be done in Latvian language only, and thus restricted the use of Russian. But the balance may also occur between identities belonging to different categories. The recent example of the Irish Constitution is a good example of this. Until 2018 and liberalization of abortion in Ireland, there was clearly a constitutional balance in favor of a collective identity and against a non-religious and individual identity, especially the possibilities of its expression. However, even in the absence of an explicit provision systematically imposing collective identity and its practices, Irish law has previously been able to become more liberal on another aspect, such as sexual orientation, by authorizing same-sex marriage, even though Catholic religion does not allow it. In this case, the importance and legislative weight of the collective Catholic identity enshrined in the constitutional text is losing influence when individual identity is favored. The balance between the two types of identity is therefore encouraged by the secondary constituent power and confirmed by the constitutional judge. In fact, the content of the constitutional identity is both the dynamics of this balancing act between identities and the result of it. Let's turn to the second part of my development. Constitutional identity as an identity given to the principles of constitutionalism. The constitutional identity guarantees a certain interpretation of the Constitution, or more precisely, of the constitutional principles which are in reality shaped by the different identities which have been chosen. Firstly, different interpretation of concepts. Very often, the choice of identities to be included in the constitutional text goes along a selection of measures reflecting this. This has an impact on fundamental concepts. In France, the collective identity excludes from the public sphere the existence of minorities as well as the additional rights granted to them. In a decision on Corsica, the Constitutional Council rejected the existence of the Corsican people, considering it was contrary to the principle of unity of the French people and indivisibility of sovereignty. The court thus protects the unitary form of the states. On the opposite, states that recognize minorities or communities sometimes grant them specific rights in order to allow them an easier access to representation in parliament or a right to veto in the adoption of certain types of law, for example. Here, the concept of the state can change if, as in Spain or Italy, certain regions have competence which are different from others. They represent asymmetrical regional states. The concepts of democracy and of the people may also be impacted. For example, in Bosnia and Herzegovina, the free expression of citizens is not based on their individual equality, but precisely on their difference as three constituent people. Such democracies are constitutional and the peoples are multinational. In short, this concept of states, democracy, people, for example, have different interpretation and application depending on the state which is considered. The identity chosen in the constitutional text and the importance given to them are at the origin of such differentiation. The interpretation by the Constitutional Court may also put different emphasis on the protection of fundamental rights and the guarantee of the rule of law. For example, the Russian Constitutional Court upheld an ad hoc and circumstantial limitation to the freedom of expression linked to the possession of an individual identity, namely the possibility of promoting homosexual orientation towards minors on the basis of constitutional moral values in particular. In another field, on the occasion of the ratification of the Charter for Regional and Minority Languages, the French Constitutional Council explained that the freedom of expression enshrined in Article 11 of the Declaration of Man and Citizen was to be reconciled with the language of the Republic, which is French, enshrined in Article 2 of the Constitution in order to limit the use of regional languages. In sum, the identity embedded in constitutional law determines the interpretation of the principles which are very heterogeneous and which are at foundation of constitutionalism. Here comes the notion of constitutional identity as a guarantee for a particular interpretation of the principles of constitutionalism. The recent inclusion of the notion of constitutional identity in the Hungarian constitutional text or of Russian cultural identity in the Russian constitutional text is not just symbolic. Their role is to give a tool to the judge in order to provide coherent and consistent interpretation of the Constitution aligned with the identity considered as collective and to which other identities must conform in the public space. When constitutional identity is mobilized by a constitutional court against a supranational rule, the domestic courts intend to protect a certain interpretation of principles that are nevertheless common to the member states of the Council of Europe. In a preventive way, the Czech Constitutional Court, in its decision on the analysis of the compatibility between the Constitution and the Lisbon Treaty, chose not to define the principles that make up the hardcore of the Constitution. On the contrary, the judge would have to give up this minimalist approach if he found that the Czech values has been abandoned, since he would have been obliged to find that, despite the words, the European and Czech principles were different in terms of identity. The Hungarian Constitutional Court has been much more precise in its definition of constitutional identity. It gave it a higher status than the will of the constituent power and associated it directly to national values and traditions. Tamás Solyok, president of the Hungarian Constitutional Court, explained in a lecture given at the Slovak Constitutional Court in 2018 on the occasion of the 25th anniversary that identity is directly linked to fundamental rights. According to him, the decisive question is, when do individual human rights prevail and when do we have to give priority to national identity? The Constitutional Court's preservation of constitutional identity provides an answer to this question. In this way, the balance between identities is tipped in favor of the chosen collective identity. To conclude, identities are interdependent and influence constitutional law, more precisely the principle of constitutionalism. Constitutional identity is a notion that ensures such an arrangement, such a system between identities. It finally appears as a positive translation of the identity of constitutional law. The concept of constitutional identity, understood as the identity of constitutional law, results from the choice between identities made by the constituent power, which is more specifically guaranteed by the judge, and from the importance given to them in relation to each other and their possible reconciliation or exclusion. In this way, constitutionalism cannot be separated from the substance of the identity of constitutional law and oscillates in Europe between universalism and particularism. Thank you for your attention.
Thank you so much, Dr. Alessard. I'm really happy that we managed to figure out how to work your microphone, and thank you for a very interesting and thought-provoking paper. We will get back to questions and comments later after, but I'm really glad it worked out so we can listen to these important research results that you present. Thank you. Then it's time for me to give the floor to Ilke Gökhansen, who is a researcher at the Center on Law and Social Transformation in Norway, and you will speak on the topic Constitutional Identity in Crisis, Populist Constitutionalism and its Effects. Please go ahead, the floor is yours.
Thank you very much, and thank you to the organizers who really put me after Lorraine, because I think she made a great presentation. I'm really looking forward to read her book or PhD thesis, because my presentation may make sense in the broader context of her presentation. Well, I will argue that there's a new and distinct form of populist challenge against the constitutional identity. And my point of departure is the populist perception of the pure unified people and crudely majoritarian conception of people's will. I will take note of different models of constitutional identity, mostly deriving from Michel Rosenfeld's work. And this will take note of different models. As a case study, I will focus on Turkey for obvious reasons, but I will have to get the definition thing out of the way because I want to make it clear what I mean by constitutional identity. I mean it in a strict sense. And I think there are two clusters of meanings as regards to constitutional identity. The first refers to an encompassing constitutional regime in which the particular constitutional provisions are interpreted particularly by constitutional judges and the political conduct that takes place according to the principles resulting from this identity. I think it comes closer to l'esprit de la Constitution, the soul of the Constitution to some extent, but given the modern developments, it has a more encompassing meaning than that, particularly in the sense that there is an interaction and dialogue between the environment of the Constitution, which makes it a constitutional identity. But my use of constitutional identity is more strict and more narrow, and that I will take the we concept of the constituent power, and it refers to the author of the Constitution, who made the Constitution, and who's the constituent power. Secondly, it is the recipient of the Constitution for whom this Constitution is made. So when I say constitutional identity throughout the speech, it means that the identity of the constituent power or identity of the constitutional subject. It may be subsumed in the broader sense, but what I use constitutional identity is the identity, as we commonly say, as a constitutional catchphrase, the V problem. To understand that, just a one word, not to remind all the cliches to everybody who knows the thing, but the common premise in the literature about constitutional power is the question of legal evaluation is a challenging subject and creating endless discussions. This is generally called, or is generally discussed under the name of paradox of constituent power. As an analytical framework, the French conception of the pouvoir constituant originaire and the pouvoir constituant dérivé, the first one is original constituent power, may translate to, and the second may be translated as derived constituent power. The first one, the original constituent power, refers to a metalegal concept and has a non-legal nature. So according to this view, particularly positivist lawyers say that we don't really have to care about what is the legal base of the original constituent power, constitutional making, but we can legally analyze and evaluate the derived constituent power, the amending power, whether it is done according to the existing constitution. So this is the reason, and this is the French way of getting out of the paradox of constituent power, but the paradox remains there because it calls for still binding a legal base of the legal base and source of the source. And it's hard to grasp for human mind because constituent power refers to creation ex nihilo. So the theoretical question is who should be the creator of the constitution, but at least for legal positivism, the constitution is itself the creator of the whole. So this is something like the Big Bang theory or the gas creation theory that the logic may stop to think. The same paradox we may observe in the V problem. The V, who is the creator, who is the subject of the constituent power, and the modern age and enlightenment gave this right to the nation, but the paradox remained since then until now. The nation, while creating the constitution, simultaneously found itself in the course of self-legitimation as a new agent of constituent power. Well, Rosenfeld says the constitutional identity and national identity are not the same things, but when we see in the nation state, the nation is always the common denominator of the collective selfhood, collective sameness as the subject of the constituent power. There are three models that we can send to V in each of them. The first one is the German ethnos model. It is the existence of eternal pre-political bonds cemented through, I'm quoting Michel Rosenfeld here, through a common language, cultural and historical bonds having absolute primacy, which is fully formed, perfectly formed prior to the adoption of the constitution and the advent of the state. So the constitution making is only a verification of this very historical absolute fact. This is ein Volk here. And on the other side, there's the French demos conception, and also presumes a pre-constitutional identity as the German ethnos, but it's a loose congregation. It's a le peuple français. It's not a nation, which has become only nation only after the revolution. This revolution has its normative aspects, resisting the tyrant in solidarity and in equality. And only after this resistance that the French nation comes as the ultimate source of sovereignty. Then the V here fully formed. And in its more concrete or 3D sketch version is the abstraction, the 3D sketch version of the abstraction of nation building by the Constitution we can see in the American Constitution's preamble, which says we the people with its wording. And we refer here to a future projection of a nation, and its reason of existence is clear. It's to form a perfect union. And the French and American models are revolutionary in the sense that they depose the old order and negate the old order. But encompassing all these models and valid for every constitution, the V is the key normative element that develops and protects the constitutional system and the whole legal order attached to it. But we have to remind that the construction of the V is always a work in progress and subject to evolution. The classical example is the V in the beginning of the United States was the white American man, and it take about 200 years to really reach to this today's melting pot. This reminds the dynamic and flexible feature of the constitutional power and the constitutional identity that is attached to it. According to this view, the constituent power is not a static, unique, or unchangeable demos, and it is always moving upwards and downwards, and it's always moving between different subjects. The examples are during the dissolution of the empires, civil wars, secession movements, decolonization after the Second World War, and more recently, post-communist state creation, where different constitutional identities were born. Also, the problem of creating a supranational demos, the European integration, and subnational challenges, Quebec, Scotland, and Catalonia, to give examples, are the contemporary issues to be reminded in that context. The populist challenge adds a new dimension to this problem. The populists, and when the populists are in play, we cannot talk about dynamic and flexible nature of the constitutional identity. We can speak about the populist destabilization of the constitutional identity and the whole constitutional order that is attached to it by horizontal, self-inflicted, and at times retrospective definition of the questioning of the we as the past and present subject of constitutional power and as the past and present constitutional identity. There are three different features that define the populist threat or challenge, more euphemistically, against the constitutional identity. The one is the constitutional challenge, the populist challenge is, as I said, it's caused a destabilization. So it's not about dissolution or fragmentation, it's a destabilization. As opposed to the dynamic feature, it is not dynamic, it is volatile. The dynamic concept, like subnational challenges, refers to a dialogue between the competing forces. The dialogue may be benign, like in the case of Quebec versus the Canadian federal government, or it may be violent. There may be a bloodshed, but it's still a dialogue between, for example, today in Sudan, during the constitution making, the democratic forces versus the military. And after losing 200 people, the military had come to the terms with the democratic forces and agreed to make a secular democratic constitution, maybe first time in the history of Sudan. So in the populist case, however, there's not a dialogue. There's a narrative of victimhood, which the oppression of the real people by the elites. There is an historical mistake. There is the enemies are not clearly identifiable, but lurking around. So there is a monologue here. It is horizontal. The populist challenge against the constitutional identity is horizontal. This is particularly true when the populist leaders interaction in the government, whereas other constitutional identities are either subnational or supranational, and there's a problem of transfer of sovereignty between the one locus to another. In the populist concept, they only want a redefinition of the we from the same level. So it's not from up and down, or it's not from a minority to a mainstream majority of constitutional identity. Having said this, these identity crisis, populist identity crisis of the we is self-inflicted, and it's retrospective questioning of the we. The we here is not happy with itself, so it projects an alternate we, comprising an ideal, genuine, common people. So the Benedict Anderson's imagined communities here is replaced by populist autocrats' own imagination or delusions, if you will. And populism is a large concept, so I'm not going to discuss what it is. But when populists meet the constitutionalism, there are many threats. Firstly, the populist leaders, once in power, they aim to perpetuate their unchecked political power. And populists are prone to be authoritarian, but in contrast to military regimes or other sort of dictators, they do not openly denounce the democracy or democratic tenets of constitutionalism. On the contrary, they speciously invoke the tenets of constitutionalism and rule of law. They're the best Democrat, they are the best protectors of the rule of law and constitutionalism. So this is the one thing that it makes us hard to fight with the populist tendencies. What stands out here is that they attack institutions in the sense of anti-majoritarian institutions, particularly constitutional courts, and institutions in the sense that respecting the formal procedural constitutional framework. On the top of that, they have a sense of moralized anti-pluralism. They have their own definition of nationalism, but which is different than the ethnos, for example, which is different than Nazis or Schmittian conception of nation, which is volatile, which may change, the members may change at the whim of the or the daily political necessities of the populist regime. Having put this is my theoretical framework, which is in progress, that I would like to open for debate, and I can apply it to Turkey, which is obviously for every purposes is a populist autocratic regime. The sociologists and political scientists are examining Turkish populism on one paradigm, which is traditionally accepted as a pivotal paradigm, which is saying that there is a disharmony between, since the Ottoman era, but particularly from the foundation of the Republic, there is a disharmony between the ruling and intellectual elites of the center and the culturally, but mostly the religiously devout, diverse periphery. It is used and overused for the most of the time. So also that may seem a little bit simplistic after 100 years, but it's still useful, at least in the sense that the populist leaders are abusing this, the concept of cultural differences between the center in the meaning that not Ankara maybe, but more the cultural center, Istanbul, or some places in Istanbul, some people, not maybe geographically defined, but defined in the name of the institutions of cultural way of life. So a recurring theme in the speeches of Erdogan's speeches, current populist leader of Turkey, is the battle between the devout Anatolian periphery and the secular elites who condescend to conservative values of the genuine people. What I can say as for the analytical framework of examining a populist destabilization of the V problem, we may do it until three titles. The one is the inclusion and exclusion, creating the new V. Second one is creating a new national identity, which is not the same as constitutional identity, but which is in a really clear, close relation and interaction with it. And the third one is blurring the line between the constituent power, blurring the line between the constitutional politics and daily politics, or blurring the line between the constituent power and constituted power, blurring the line between the original constituent power and derived constituent power, since populists attack the old institutions. So the first one is creating a new political man, creating a new we, creating a new citizen, finds itself, at least in the Turkish case, in inclusion and exclusion. Inclusion here means the representation. It implies improving the socioeconomic, cultural, and political status of previously marginalized groups, which in Turkey are the people who live in the depth of Anatolia, having a religiously devout life and who do not have access to political, cultural, circles, and really as narrow as they say, as narrow political, cultural, and intellectual, artistic circles. So this is the periphery. By expressing respect for them, and it's a quote, and affirming their importance and political power through rhetoric and action, the party, the Justice and Development Party, and particularly its leader, Erdogan, today's populist autocrat, President Erdogan, has successfully realized a symbolic inclusion of once excluded and alienated masses into politics. One emblematic example of this is the Mokhtar meetings since the election as a president in 2014. Erdogan has started to hold regular Mokhtar meetings in his presidential palace, welcoming and honoring the Mokhtars as the real representatives of the people. What is Mokhtar, by the way? It is in post-Ottoman states, including Turkey, Middle East, and Balkans, is the head of the village and neighborhood. It's a public servant, but elected by the relevant constituencies. Mukhtar refers to the lowest level of the political career, as well as in Turkish daily speech, it may be used as a way of contempt, as an idiom, as an insult to denote people who have nothing else better to do and to interfere with the other people's business. So this was the headlines when Erdogan was crushed by the then establishment, the late 90s and 2000s. The headlines went like, he can't even become a Mokhtar, which means that he can't even rule a village or neighborhood, let alone the country. So against this backdrop, Since 2014, Erdogan has been having regular meetings with the Muqtars, always starting with a speech that you are the real nation, you are the real representative of the people, you are the Muqtars, who are the real majority, who are the real Turkish nation. On the other hand, there's the exclusion. The political space is open only those under following the current parties and Erdogan's definition of people, the genuine people, as the populists say, the oppressed people against the elites, and whoever considered as the elites are left out of the political space. This is called a moralized anti-pluralism in the literature of populist readings. There are many examples of exclusions here. Do I have time, by the way? Because I thought it was 20 minutes, but
A couple of more minutes, please go ahead. Yeah.
okay, then I will. Okay, then I will wrap up. And I will give you, okay, then the most important one, that the post-coup purges, the emergency decrees purge about more than 100,000 people from state institutions, as well as they were left to a civil death, so much so that they're colloquially called as the emergency decree person. KHK is the abbreviation of that in Turkish, KHK person, to denote the untouchables of Erdogan's Turkey. Another example is Osman Kavala, the philanthropist, still in prison, pending trial for conspiracy against the government, still in prison about more than 2 years now, despite the European Court of Human Rights decisions of violation regarding that. And when he was first detained, a pro-government columnist and Erdogan's ex-consultant commented detaining Kavala was a revolution. In a sense, because to be able to touch Kavala was to be able to touch the cultural hegemony of the imperialist West. If you just Google the name, you can just find, just looking at his face, you can see that it is diametrically opposed to what people see as the genuine people. Osman Kavala is diametrically opposed, an Istanbulite, well-defined, well-groomed, and very, very well-intellectual gentleman. So this is one example. The second title is The New Nationalism with its myths and symbols. It's particularly after the attempted coup of 15 July 2016 marks the beginning of Erdogan's new nationalism, where he creates a new history of resistance, a new history of revolution as the founding myth of the new Turkey. Also, this day is now commemorated as the March Years and Democracy Day, ironically, and taught in primary school curriculum. Thirdly and lastly, there is this post-2016 deconstitutionalization. Oh, I thought I had a hard time to in saying that word, but dismemberment of the constitution of Turkey and 2017 referendum. Following the attempted coup since 2016, we can say that Turkey has a nominal or facade constitution. The constitution is in a standby position, and without actually abrogating it, the political power rendered it dysfunctional. The critical moment is a constitutional court decision right after the coup, abandoning its long-standing jurisprudence about its competence to review the constitutionality of the executive emergency decrees. This decision saved Erdogan from all constitutional constraints, and in practice, within the 2 years between 2016 and 2018, in practice and in reality, it acts as an original constituent power in the guise of a constituted power and in the guise of the right constituent power, because there was a referendum held during this period, which changed drastically the political regime of Turkey and entrenched a very autocrat and authoritarian constitution. And this comes very close to a Schmittian conception of constituent power, the substantial homogeneity of the identity and the will of the people. And this is realized by referendums, because for Carl Schmitt, referendums are the public appraisal of the Führer, in whose personality the unity of the nation is revealed. But the populists take the worst of two worlds. They learn from history. So they use the ethnos and they use the revolution, demos, at the same time. It is the ethnos because there was the campaign, the referendum campaign was utterly exclusionary. For example, President Tayyip Erdogan in a campaign rally said, the separatist terrorist organization says no. If you say no, you're a terrorist. And if you say no, you are sided with the terrorists. So you have to say yes in order to be included in the nation as we define it. Second verse from revolutionary world is it was a symbolic act of revolution because it was the referendum was made right after this attempted coup, and the timing was very important. And the society was confused, particularly pro-Erdoganist people were confused and traumatized. And the history of narrative of the victimhood was also coupled with this traumatization and confusion. And overall process was carried during the emergency period, where Erdogan ruled by decrees without any limits, as I mentioned. So thus, in fact, there was a legal vacuum here in 2016 and 2018 by the hands-off approach of the Constitutional Court, which is the characteristic of the original constituent power. To conclude, the populism is a one-off constituent power, is a deposable constituent power that can't stabilize itself into a rationalized state in a Weberian sense. There's a constant political polarization, reinventing the national symbols at the whim of the autocrat. It can change every now and then. And use of ballots as political mobilization may be noted here as the populist general destabilization of the constitutional order. And it is for sure, it's the same for Turkey. And the line between the daily politics and constitutional politics are blurred. And the events surrounding the 2017 referendum showed that the populist government acted as the original constitutional power in the guise of the derived constitutional power. Same is true for daily politics. Even, for example, in 2019, the local elections became a matter of life and death. Erdogan contextualized the election as the survival of the Turkish state, the fraternity, the unity and prosperity of the nation. That was just local elections, and Turkey is a strictly unitary state, and it has nothing to do with the fraternity, unity, and prosperity of the nation. From a constitutional point of view, the last words of all these events result in the destabilization of the whole constitutional order and eventually the identity of the constituent power itself. I know this is a little bit brave argument, and every time the actors do not abide by the constitution, do we say that are we in the sense, are we in the stage of original constitutional power? It's up to debate, but at least for Turkey, I can say that between 2016 and 2018, it was the populist attack against the constitutional identity and the constitutional order. Thank you very much.
Thank you so much. Very interesting. And indeed, it follow-ups on what Lauriane was talking about in an excellent manner. So I'm looking forward to the discussion afterwards. But I want to go ahead and give the floor to Assistant Professor Cristina Gazzetta. And is Giovanni D'Alessandro also with us, or will you give the presentation alone, Cristina? You have to unmute yourself. We can't hear you. Maybe Anna can unmute Cristina. Sergey? Oh, okay.
Okay.
Please go ahead.
I will speak alone, Anna.
Okay.
Je ferai ma relation en français.
Okay. Well, okay.
Merci. Alors, je voudrais remercier les organisateurs de ce colloque, même au nom de mon collègue Giovanni, car dans ces jours, il est engagé dans une commission nationale des concours.
Well, unfortunately, my colleague Giovanni is in court today, therefore I'm going to deliver my report. So the crisis of a liberal state that emerged, it provides new complexity and a new diversification, being forced to present different components and to find solutions for the social conflicts that will emerge as a consequence. The integrity of the state system loses its value, and as a result of that, the unity strengthening should be questioned, because we see the continuous growth of social tension and complexity. The idea of multiculturalism is not just a national identity issue, but also the issue of emergence of new ethics, and it is explained by migration from different countries. And we see this, that these people have pronounced identity and they move to neutral countries. And shortly, I will try to demonstrate how this idea of multiculturalism within the framework of a national state is moving forward, and how do we the different participants organize their dialogue in such a varied environment. Sovereignty and civil rights support the cultural identity of constitution. And shortly, I would like to give information about the minority provision. In order to define the concept of minority that may be better adapted to each particular case in every state, we need to remember the activity of Venice Commission that emphasized the need to expand the rights of minorities to people who are not citizens, and thus they demonstrated the need to reconsider this idea that minorities are connected as part of a state. However, the Venice Commission has noted that this choice will lead to the fact that the majority will isolate minority because this group has its own characteristics of identity, and this group is different from the majority. And I would like to remind you that after the Second World War, a commission was gathered that formed the system of rights protection that it focuses on human rather than on belonging or not belonging to a certain group, and being based on this group of minorities will lead to this discrimination among minorities. If you focus just on what, and federal state, as they believe, will lead to legal recognition and peaceful coexistence between different groups that are present in the state. But this choice provides for the assessment and recognition of groups of minorities, and it does not suppress the, and it actually does not allow to promote the rights of other minorities. And as a result, the federal solution should not be considered as an individual or a better one. And it was mentioned that fundamental or basic rights of subjects as members of the group actually are replaced by subjective rights, and people are in the focus of many legal situations. Each of them deserves protection. And it's easy to demonstrate that if you consider if you consider the European Convention on Human Rights, and this demonstrates that there is a multi-layer protection. One Convention Article 14 says that the use of rights and freedoms is not associated with the restrictions on gender, on race, religion, the color, or national or social background, or the belonging to a national minority. Regardless of the fact that Convention has no information on equality on essence, in addition to formal equality. And it also has information that we may have some negative protection of minorities. And it's obvious that those documents that state positive protection of minorities have certain risks to violate this equality rules in accordance with rights of people who are covered by the sovereignty of the state. And it's necessary to emphasize that the conflict between the citizens and non-citizens and minorities does not necessarily lead to well, it requires a differential approach. And as a result of that, we know that minority protection is not considered as a type of nationalism, but is rather considered multinationalism consideration, where citizenship provides not just for ethnic rights, but also for broader ideas of collective rights that will lose their essence. And also after the consideration of the group, there's yet another idea to share. The new charter that was adopted in October 2007 in Montenegro and it defined the sovereignty of citizen along with citizenship, supporting the concept of the new cultural constitution concept on June 2006. Montenegro announced that it is an independent state. And it should be mentioned that the recognition of rights for separation of 2003 had certain consequences for the collapse of the Federal Union, because it's obvious that there is a contrast between the legal principle of divisiveness and between the right of subject to be isolated, and the union of Serbia and Montenegro was defined by the constitutional charter that is not the constitution for obvious reasons. So that's not a state, but rather a union of the states. In international law, we also have those who define this 2003 charter as an agreement of, as an international agreement, though it's not a bilateral agreement. And it was adopted by the Parliamentary Assembly, and it follows the agreements of the previous centuries between the two subjects. Montenegro text really takes into account the cultural variety of the groups represented in the state. But the path that Montenegro subjects take into account the variety of cultural units in the state, supports a common goal of peaceful coexistence, because these groups need to have protection of their identity, and this is an important element to support a continuous dialogue. And here we're talking about a competitive model that, unlike in Serbia, has this inclusion type, and it wants to attach strong national identity to people, where citizens should stick to the national identity, and national identity is seen as a strong point for territorial for this country's integrity. And this idea of sovereignty is particular here. And here we understand that sovereignty carries the citizen that has the citizenship of Montenegro. And this forced transfer of citizenship and citizens can correspond to different situations, because the first term, citizen, is juxtaposed to state participation. And on the territory of Montenegro, we may have citizens that belong to different national communities, and they can be connected to different states. And quite frequently in many states of Eastern Europe, they have a division between citizenship and nationality, and this representation of sovereignty, it has no correspondence in the Western tradition, because according to the French Revolution principles that is enshrined in Constitution, the unified, it belongs to the nation. The sovereignty belongs to people, and it is characterized by the presence of citizenship, and the nation sees no differentiation option here. And in Montenegro Charter, citizenship also corresponds to the membership in the dominating ethnic group, or in one of these groups, and thus to the political consensus regarding the idea of a nation of the dominating group. And in fact, in preamble, we read that, taking into account the decision of people to live in a free and independent state of Montenegro, adopted at the referendum in 2006, based on the decision that we as a free citizens that belong to national minorities living in Montenegro, we have this free citizenship in this country. The choice of subjects of federation is the breach from what was previously announced by the 1992 constitution that said that sovereignty belongs to citizens with a reference to people who are living on the territory of Montenegro, not to the passport connected to ethnic background, as it was described in the Federal Constitution of 1993. Whereas in Serbia, where Serb ethnic group is prevalent and it's the major group, the Constitution of 2006 states that sovereignty is based on citizens, and they use their sovereignty through national initiative, through referendums, and through elected representatives in order to expand citizenship as much as possible, to recognize the Serb ethnic group as a group that created the nation. Therefore, it's legitimized as the dominating group. And in Montenegro, where the ethnic structure is much more fragmented, they warned about the need to achieve legitimacy through the civil model of the nation. And here we can talk about the confrontation. And when minorities are unable to question the choice of majority, we may have certain problems. The new constitution of Montenegro provides for dual citizenship that can be preserved after bilateral agreement with another state, no later than a year after the adoption of the new constitution. And as a consequence, citizens of Serbia that live in Montenegro that decide to preserve their Serbian citizenship, this should be considered as foreigners in Montenegro, and this will give way to new political community that will challenge the situation and may lead to a crisis of the previous situation. And the choice of Montenegro is easy to understand if you I think that dual citizenship was provided to defend the human rights in a region that had very strong conflicts, ethnic conflicts. From this point of view, Serbian parliament made yet another step, adopting quite recently the measures that are likely aimed at a different direction compared to those that were provided for Serbian citizens. And there's a guarantee that Serbian citizens that live in before the independence of Montenegro would easily get passport, and residents could give away their passport. And this, the guarantee of existence of minorities, so the guarantee of national variety is defined well in constitution, in Montenegro constitution. That provides in Article 79 not just the right to preserve the identity and to express their identity, but also the rights that are directly dealing with public structures. Therefore, it's expedient to remind about this right to demonstrate national symbols, and about the right to celebrate national festivals, about the right to use language and alphabet in ordinary life, and also the right to get education on the native language, and to learn the history and culture of national minorities during school studies, and the right to have local education, local authorities in places where it's relevant, the litigation right, the right for efficient representation in the national parliament and in representative bodies, the right for information on the native, to get information in the native language. However, the Serbian constitution recognizes the rights only for national minorities and the rights in education and administrative sector, where it's obvious that this term of national identity is limiting the application of certain rights, excluding the groups that are quite numerous but still are not connected with other states and that do not belong to this group. And the guarantee of existence of such minority groups is defined in the Serb constitution, which is something that Europeans don't know well. And it should be mentioned that the Constitution of Serbia recognizes the rights of national minorities. And in Article 80, there is a ban on a forced assimilation of some identities that states the need for the state to protect such communities from assimilation attempts. And in conclusion, I can say that the reality of Montenegro offers an interesting insight on the composition, national composition, and it influences the choice of administration, and it should provide for a constructive dialogue. And these relations should not be considered as a dialogue between ruling majority and minorities should not just have the protection of their identity as in case of Serbia, but also they should get the right to protect the specificity of every group without any difference between majority and minority, as it's stated in the constitution text of Montenegro. And it was emphasized that this notion of citizenship should not be understood as a limitation for the implementation of sovereignty that is thus transformed from sovereignty of the nation into the sovereignty of a citizen that recognizes itself, that recognizes the values of the state. And it was also mentioned that federal decisions are not enough if we talk about minorities, because sometimes there's the recognition of the state to of the need to protect the specificity, because frequently we see such minorities that would not do not have such characteristics that would strengthen the federal conflict between other groups. The sovereignty should be reconsidered. Sovereignty that will not just become a multinational, but also multicultural, in order to maintain for democratic values and the rule of law in every state. And the new social pluralism should implement the principle of unity in complexity, where the rights of minorities will not restrict the values, but they will have legal representation that will allow them to better protect their inherent characteristics. Thank you.
Thank you so much, Professor Gazzetta. We're running a little bit short on time, so I want to go directly to Yekaterina Kalinina and give you the word. You're a senior teacher at the Ural State Law University in Yekaterinburg, Russia. Please, Yekaterina, go ahead. No, you were perfect. Yes.
Is there a sound? Yes. Okay. And I need to change this. And a second to push the demonstrate the presentation. Could you see the presentation? Okay. Okay. So good afternoon. First of all, just a second. So good afternoon. First of all, let me say a big thank to all organizers and the whole team, and especially to Anna Gritsenko for this amazing and brilliant management of this professional event, this forum and this roundtable, and of course to all speakers and our coordinator. So it's a personal honor for me to be involved in such a professional event. And yes, as for me, my name is Yekaterina Kalinina. I represent the Ural State Law University located in Yekaterinburg City, Russia. I'm a lecturer there, a senior teacher, and today I would like to speak about the role of constitutional identity in the human rights protection and the challenges of the globalization. So I divided the structure of my presentation into 5 blocks, and step by step would want to illustrate the following issues concerning the transformation of the constitutional identity, types of constitutional identity transformation, some challenges concerning the, okay, yes, I also see this. Just a moment. I even don't know, have no idea how to, maybe, no.
You can use the arrows to go down if you want to show slide number 3.
Yeah.
Yeah.
Could you see? Yes?
Yes, we can see.
Okay,
Yeah.
I may proceed. So I would like to start with the point that I believe that the declaration of constitutional identity is an important strategy for the domestic policy of each state. And nowadays, the historical well-known phrase, l'état c'est moi, finds a new interpretation. For this contemporary new meaning, it means that each state possesses its own individuality or its own I am. We may just illustrate it like I am the United States of America, here I am Italy, and this is my constitutional identity. So the states tries strengthening and showing their constitutional identity to the world. So each constitutional identity comprises many elements of the many basic elements, and basic of them enshrined in Montevideo Convention 1933. They are permanent population, defined territory, government, and the capacity to enter into relations with other states. So that's why constitutional identity anyway shall reflect an ethnic, ideological, or religious issues like population criterion within its borders or outside, and via its public bodies using the system of check and balances, because the system of check and balances still remains a very effective tool for building their identity. So there are many deliberations concerning the term of the constitutional identity as an individuality, or even identity as the sameness. For example, when we try to compare some countries and find some common and similarity or some common or similar features of these states. Also, there are many deliberations concerning the notions like national identity, state identity, or constitutional identity. But what makes the issue more controversial is the dynamics and sensitivity of the constitutional identity to various factors. So I'm absolutely sure that there is no absolutely fixed, certain constitutional identity of the state. The constitutional identity is subject to incessant transformation, voluntary or forced. So, for example, voluntary transformation becomes, as a rule, as a response to the development of society, some scientific advance or discoveries, and forced transformation is the reaction to some crisis. So, as for the types of transformation and as for the factors, we may underline that we may divide that the transformation can be forced, voluntary, or mixed. I call it consciously responsive transformation. For example, in the past 5 years, there was a tendency to amend the constitutions, and I'm sure that I guess that Lorianne knew it very well. And for example, there were amendments to constitution in Albania, Austria, Greece, Russia, and Brazil, Georgia, all over the world.
And this action initiated by the population or by the authorities directly affect the constitutional identity, consolidating the main political, social, economic, and cultural foundation. As a result, as a general rule, all amendment to the constitution is a sovereign act of the state, and in this event, the transformation occurs in any way, and this transformation will be voluntary. But in the other case, when the when the amendments to constitution were made under some internal or external factors, so under the pressure, for example, reasonable and real threat of invasion or violation of borders, or for example, external undermining of some foundation of the constitutional order, or for example, even the decision of international bodies, which is binding on the state. So in this case, the state made these amendments in order to fulfill this obligation. In this, so these actions were compulsory for the state, and in this case, the transformation of the constitutional identity will be regarded as first. So the mixed type of the identity transformation meets all the complexity of the modern relations, and when any changes can be submitted as voluntary, but at nature, they forced measures to overcome some conflicts. An example of such mixed or consciously responsive transformation of the constitutional identity can be amending the country's constitution, but not with the aim to fulfill the international obligation, but for bypassing them. And this is an example of amendments that were enshrined in the Constitution of the Russian Federation. Again, Lorian was talking about these amendments because to our constitution were made some provisions which declared that decision of interstate bodies, if this provision contrary to our constitution, are not subject to execution. Also another criterion to divide the constitutional identity and its transformation, it's the planned or sudden transformation. So sudden transformation is the identity's response to certain factors, both obvious or hidden. Sometimes even a tiny point change following the butterfly effect may influence or can be subsequently became a root cause of the transformation of identity. For example, coronavirus pandemic has become an obvious and direct factor that demanded some changes, restrictions, and deviations in the legal regulation of many countries, and especially in the sphere of human rights. And certain scientific discoveries, such as invention of the wheel, invention of the computer, and the spread of internet, can also have an impact on the constitutional identity of the state after a certain period of time. So in this regard, there is no chance, so it is impossible to enumerate all factors that can influence on the matter of the constitutional identity. There are a million of them. Not all of them are explicit, but the modern period allows us to attribute the following phenomena to the challenges of globalization, such as integration, anti-globalism, and the crisis of humanity. So as we speak to the challenges of globalization, the issue of globalization are elements of paramount importance in this case, and European authors were the first who used the term national or constitutional identity in order to positively assess the existence of European Union, but later then to criticize this organization, which infringes on some
real constitutional identity of some member states. So integration itself arises the question of the constitutional identity, and the European Court and the Supreme Court or Constitutional Court or relevant bodies within the European states in their case law made many important provisions concerning this issue and tried to build hierarchy of supranational and national regulation. And one of the case when the European Court suppressed the constitutional identity of states, for example, was the Mega case. You may see also, okay, you may see other cases also on the in the presentation, and I would like just to remind, for example, a Mega case when the European Court did not recognize the actions of the authority of the German city, where games of laser weapons were banned because the game violates human dignity protected by the laws of Germany. The European Court of Justice pointed to the uniform application of freedom of services and also pointed to the fact that union law does not impede economic activity concerning commercial games simulating acts of murders. So as a response to such similar decision of the European Court, some states, France, Germany, Poland, defend a certain position of regarding the constitutional identity. And again, we may refer to the case of the Federal Constitutional Court of Germany of 2009, when the Constitutional Court stated that the integration itself presupposes coordination and joint actions, but not the rejection of the constitutional identity. And therefore, there is the double intention of many of states, on the one hand, to define themselves in some international organization, but on the other hand, try to oppose the constitutional identity to the uniformity of practice. So as for the anti-globalism, anti-globalism also has the power to influence the content of the constitutional identity, and accordingly, the greater the influence of the anti-globalization within the country, the more likely the taking political decision may not coincide with the position of international bodies or organizations. So in this regard, we have a burning challenge how to include or how to coordinate the international law and national law within one legal national system. So many states are still in the continuous process for such a balance. And as for the crisis and pandemic, also I believe that all crises affect the constitutional identity, and we cannot omit the fact that the constitutional identity grows in times of crisis. For example, the period of 2008 and 2012 associated with financial crisis. And to overcome the devaluation of the national system, some of the countries made their own regulation, and some of the countries were forced to address to international bodies, for example, Greece asking for lending, and for example, Cyprus asking for restoring the banking system of the state. The next example is migration crisis associated with the massive influx of refugees from Africa and the Middle Eastern states in 2015 and 16, and the policy of European countries were changed radically. Some countries continue to act on the previous policy. Some states tries to
adapt their constitutional identity following the principle of tolerance. And some countries, for example, Hungary and Sweden, they closed, on the contrary, they closed their borders and thereby separating their constitutional identity from the European Union in this question. And other countries such as Greece or Italy, they faced with a disproportionate distribution of migrants, so they sought help from the other countries. So at last, you may see and the restriction that was laid in the Russian Federation to fight and to ensure the health and life of the population of the Russian Federation, and many countries facing the challenges of globalization and pandemic crisis also faced with the problem how to regulate this question and how to at the same time to follow the international law. And I would like to go to the conclusion of my report, and the conclusions are the following. So first, the transformation of the constitutional in the identity exists, and this is an inevitable process. So second, the state needs to accept this transformational features of its identity and assess the risk of transformation, its consequences and solutions while developing its domestic or national policy. Third, the challenges of globalization trigger, influence, or affect the constitutional identity of the state. Fourth, the national and supranational system of the human rights protection is an integral part of the constitutional identity. And the last, if the possibility of population to address to international bodies is also constitutes the identity of the state, and it's a strategy for the state to adopt or to confront the challenges of globalization. Thank you for your attention.
Thank you so much, Katerina. And we move directly to Gopan Sapa. Did I pronounce it correctly?
Yeah, Gürkan Çapar.
Okay, so we're so much looking forward to your presentation. Please go ahead.
Okay, thank you very much. I'm sharing my screen. Okay, I hope you can see right now. Okay, I will present, my presentation will be about the concept of constitutional identity. This will be the table of contents of my presentation, but I will just go into details because we have so few times. In Lost Empire, Dworkin tells about an hypothetical community, and they are discussing about the change in the meaning of courtesy, and they discuss that whether the concept of courtesy is still the same concept that they are used to. However, and they decide to go to a philosopher and ask this question: our practices are now very different from what they were several generations ago, different from the practices of courtesy in neighboring and distant societies. Yet we know the practice we have is the same sort of practice as those. There must therefore be some feature all these different practices have in common, in virtue of which they are all versions of courtesy. Please tell us what it is. Of course, Dworkin, as an interpretive scholars, don't like this idea of a criteria or a defining feature common to all instances or examples of that institution or a legal system. For him, everything is interpretive, and you cannot find a common criteria that will tell you what the identity of a legal system is at a certain moment, because it's a matter of interpretation. That's why we have still a constitution of the United States of 2000 years old, and it is a matter of interpretation. And that's why these questions, is there a criteria or defining feature common to all instances or examples of an institution, a legal system? Or is there something that is resistant to change and gives certain social practices its defining features? Or can we find some defining feature or criteria that may help us to tell when a legal system loses its identity and becomes something different? Is a matter of interpretation. But the important issue is that for Dworkin and lots of other legal philosophers, we have to respect to the past. It is important. That's why you cannot disregard. Your interpretation should fit to the past practices. That's why there is some identity. There is something resistant in the legal system that is persistent, and that's why we have to respect this part. And unconstitutional constitutional amendment doctrine, when seen from the perspective of a legal system and from a temporal dimension, is the doctrine preserving some defining principles of this particular legal system. Seen from this perspective, it will be clear that constitutional identity is a limitation to the amendment power, so it can be used as an argument in favor of the unconstitutional constitutional amendment doctrine. These will be the some arguments that I will use during the presentation, and these are my main arguments. We have to differ constitutional identity from national identity. This is also raised by Professor Michel Rosenfeld. Because constitutional identity is a legal concept and national identity is a socio-political and is part of a socio-political sphere. To understand the concept of constitutional identity, we have to deal with the temporal aspects of legal systems, and we have to question when a legal system becomes something different. So law should be seen as a social institution, preserving its relative autonomy vis-a-vis society, as argued by Weber. Also, society preserves its relative autonomy vis-a-vis legal sphere. And we have to think constitutional identity and national identity in this kind of a conflictual and collaborative relationship. The purpose of this study is, let's take a scientific approach, if it is possible, to the concept of constitutional identity. Let's decouple political and moral questions about the use and abuse of constitutional identity, and let's try to focus on the concept of constitutional identity per se. Let's put aside institutional questions. Who will be the supreme institutional authority to deal with the problem of constitutional identity? And let's focus, first of all, whether there can be something called constitutional identity. Also, let's put aside doctrinal questions, whether constitutional identity is different from ultra-virus review, or whether constitutional identity is different from unconstitutional constitutional amendment doctrine. And let's again focus to the concept itself. Also, let's speak also to legal theory, and in addition to constitutional theory, because if we wouldn't benefit from legal theory, it doesn't make any sense of all these contributions of the legal theory. First of all, I will just draw a distinction benefiting from constitutional theory, and this is the discussions about constitutional theory, constitutional identity in constitutional theory. As you may all know, Rosnay made a threefold distinction. One of them is unlimited constituent power, it is political, and the others are legal constituted power, and amendment power is legal, that's why it is limited. So unconstitutional constitutional amendment doctrine can be justified by arguing that every constitution has identity, and so constitutional identity can be justified or can justify the use of unconstitutional constitutional amendment doctrine. However, here we are appealing to unlimited political constituent power in some sense, and it is the political will. On the other side, there is Richard Albert's arguments, and he argues that let's integrate this unlimited constituent power into the legal domain and make it, or call it, constitutional dismemberment if some constitutional amendments are such radical that it dismembers the constitutional identity of the constitution, or amend the constitution so radically that it becomes another constitution, but everything is in the legal domain. And here I will use Laughlin's threefold distinction. Martin Laughlin, in his article in 2005 about the concept of constituent power, argues that there are three different approaches to the constituent power. One of them is normativist, the other is decisionist, the third one is relationist. Here we can see examples of normativist and decisionist approach. Normativist approach is the Kelson's approach in some sense. Everything is legal. We need only a unmoved mover and a triggering clause in some sense, a basic norm that triggers all the normativity. And this normativity can only be cut off with a political coup d'etat and a political issue. On the other side, we have decisionists like Schmidt And as you all know, no need to explain. And I think Rosnay and Richard Albert is the modern and more sophisticated version of this normativist and decisionist approach. Normativist, I think Albert's approach is normativist. Of course, it is much more sophisticated because at bottom he argues that let's put everything inside normativity and everything, let's understand everything as legal. On the other side, Rosnay appeals to Schmittian understanding of constituent power to justify the use of unconstitutional constitutional doctrine. And there is, it is at least my argument that Rosnay is in some sense the modern version of decisionism. However, Laughlin argues that constitutions can be viewed not only as a text, but also as an expression of political way of being. It is not something that is constituted, but it is also something that constitutes a nation and identity that that is already discussed during the conference. And that's why we have to adopt a relationist approach. And it is my argument that Rosenfeld's analysis of constitutional identity is a relationist one because it gives special emphasis to the concept of constitutional identity and national identity. I'm just passing this part. Now, put aside, bear in mind this threefold distinction that is made in the constitutional theory, and let's focus on now to the legal theory and how people are discussing the change of legal systems in legal theory. Because, okay, constitutional identity is a recent concept that gains significant attraction in the EU legal order, but the identity of a legal system is not a new concept. People were already discussed this concept in the mid-1980s, 70s, especially Raz with his book of the concept of legal system, and also Finis with his articles, and so on and so forth. And first of all, I would like to make a distinction between, this is the distinction made by Joseph Raz, instrumental and non-instrumental use of or side of law. In instrumental side of law, law is a functional tool that guides human behavior. That's why it provides us a framework within which we may live peacefully. However, on the other side, law has a non-instrumental side. And Dixon argues that it is not merely something that we happen to have recourse to in navigating our way around societies and their law. It's a concept used to draw distinctions which are of vital importance to us in terms of the way we think about those societies, their boundaries, distinctiveness, our relation to them, and the values to which they aspire. Seen from this perspective, it is impossible to understand the unity of a legal system by merely formal criteria, such as rule of recognition, rule of change, so on and so forth, by merely staying within the boundaries of legality. We have to go beyond. And for example, this is the material unit of a legal system. This is the understanding of Joseph Raz. And he argues that material unit of a legal system can only be understood when we just see the all-pervasive principles and the traditional institutional structure and the practices that permit the system and lend it its distinctive character. And it is also obvious that even when seen from a legal positivist, an exclusive legal positivist perspective, there is much more space for constitutional identity and unconstitutional constitutional amendment doctrine. So any argument that refers to legal positivism to support or to object to unconstitutional constitutional amendment doctrine fails, obviously. Here also I want to make a distinction about the identity of a legal system. Generally, in legal theory, the identity of a legal system used in the sense the identity of norms within a legal system. So it is about specific norms. However, legal theorians are also dealing with the identity of a legal system in a more temporal perspective. And they are discussing what are some particular and specific features of a legal system gives this legal system its identity and resistant to time and change, at least to a certain extent. Raz argues that Raz makes another distinction here between momentary and non-momentary legal systems. Momentary legal systems is the snapshot picture of a legal system at a particular moment. And it is, for example, today's US Constitution. You can just look at it today. But non-momentary legal system is the combination of these momentary legal system in a temporal sphere, and it is the approach from a longue durée perspective to a legal system. And they are dealing with how to deal with the continuity and discontinuity of a legal system. And again, here we have threefold. This is the threefold distinction I apply to the legal theory that I borrow from Martin Laughlin. On the one side, there is decisionist approach. Austin's sovereignty is a perfect example of decisionist approach, because Hart also harshly criticized Austin in terms of his explanation about the idea of sovereignty and the problem of continuity coming with sovereignty, because after Rex I dies, the people are in the obedience or are in the habit of obedience to Rex I, will not probably obey to Rex II, and you cannot explain the continuity of a legal system with this Austinian or decisionist approach. On the other side, we have Kelsen, and here there's the problem of legal discontinuity. With Kelsen, you cannot explain the discontinuity, legal discontinuity of a legal system, because two laws, one of which directly or indirectly authorizes the creation of another, necessarily belongs to the legal system. And in the mid-1970s and during the decolonization movement, lots of people discussed these kind of issues, how to explain legal devolution of constituent power to new states. And it is impossible to explain this issue with Kelsen's approach, because there is historical first constitution. This is the British Constitution, and of course, you cannot explain it. And for us, both of these approaches at bottom is an argument from the principle of origin. They are just looking to principle of origin at the constituent moment or rule of recognition, ground norm, basic norm, whatever, it doesn't matter. And he argues that we need something different. And this is Raz's argument again, Kelsen's legal system. He says that Kelsen's legal system represents not a momentary legal system, but a continuous legal system. The basic power represented in it must have existed, but not need exist anymore. The hierarchy of legislative powers in Kelsen's theory is not like Austin's hierarchy, a vertical momentary hierarchy. It's a horizontal hierarchy stretched over a period of time to the historically first constitution. All in all, there are two problems here. One of them is how to explain some changes that is so fundamental to the identity of the constitution, like Albert's constitutional dismemberment. And even though the system seems the same from the formal perspective, it is substantively a different constitution or legal system, and you cannot explain it. The other issue, every constitution making does not mark the beginning of a novel legal system. For example, in Turkey in 1982, there was a coup d'etat and there was a new constitution. However, lots of constitutional scholars, I think in Turkey, sees 1982 constitution is the continuum of 1961 constitution. Or also we can just give the same example from French constitution and the fifth French constitution and its relation to the others. So we need something more. That's why I don't want to deal with the Hart's issue here, because we don't have much time, but Raz clearly says that Hart disregards the non-instrumental dimension of law. It is the authoritative voice of political community. The constitution is the authoritative voice of political community. It is also constructive. We have to take into account this. People attach to certain constitutions because they are the constitution of their own states, and so on and so forth. And Hart disregards this part. He generally approached from a functional perspective, and that's why it is not suitable. Anyway, I would like to just mention a few relational approach legal system that is mentioned by not only legal positivists, but also natural lawyers such as Finis, also interpretivists such as Dworkin, and they are all arguing that let's focus the identity of a legal system or the continuity and discontinuity of a legal system from a relational perspective. Because Finis argues that the continuity and identity of a legal system is a function of the continuity and identity of a society in whose ordered existence in time the legal system participates. Also, Dixon argues that no need to study legal system as a self-sufficient, free-floating normative entity. It is a legal system of something. And part of the key to its identity lies in the character of that something and in the relation of the legal system to it. This is an excerpt from Joseph Raz's latest book, Between Authority and Interpretation. And he argues that the substance of my contention is that continuity depends on the interaction of legal and non-legal norms and the extent and manner of their change. And secondly, that among the legal norms concerned, some are more relevant than others. This is very important. Some constitutional norms are more relevant and more important than the others. Since the continuity of a legal system is fundamentally a function of the continuity of the political system, political laws are more relevant than others. Here we can infer, I think, two different issues. One of them is not all laws are of equal importance. And this is such important that we can build everything here. So there are some unamendable principles, there is some constitutional identity that is much more important for this constitution that cannot be changed. And we can build a whole theory of unconstitutional constitutional amendment doctrine here by benefiting from this argument. Also, it is not possible to understand constitutional continuity and discontinuity without paying no attention to the continuity of the socio-political context in which it is embedded. That's why rule of recognition, basic norm, rule of change, this may help lots of things, but it doesn't enough. We need to address these issues from a relational perspective. Here, there are some arguments. One of the, I would like to just finally deal with Postema and Honore's arguments. They argue that let's reconceptualize the basic norm as such. The members of a society have a duty to cooperate with another. And this duty to cooperation, duty to trust each other, promise that we give each other, or commitments we made at the moment of constitution making should be interpreted every time during the evolution of constitutional identity. This is the point of view adopted by Honore, Postema, in some sense also from my point of view of Dworkin. Last issue I would like to raise. Raz, in his Between Authority and Interpretation, explicitly adopts a position with respect to interpretation, an innovative position. And he argues that we need to adopt an innovative interpretation grounded in the idea of finding a delicate balance between legal innovation and change within a stable, continuous legal framework. And also Dworkin argues a constructive interpretation. I think you probably all know Dworkin's chain novel analogy and his argument of the ship of Theseus, I guess. The ship of Theseus is the issue of Theseus is sailing in the sea, is a ship, and they are just trying to renovate and change some parts of the ship during the sailing. Of course, you cannot change all of them because then you will sink into the ocean, but you need to gradually, iteratively change it. So when seen from this perspective, Dworkin's constructive interpretation and Raz's innovative interpretation is not much different, especially for the idea of constitutional identity. Of course, Dworkin has some moral issues, but when both of them is adopting the argument that, supporting the argument that constitutional identity is indispensable for any kind of a legal system, when seen from a temporal perspective. This is the latest slide, the final slide of me. This is an excerpt from Raz Between Authority and Interpretation, and he also explicitly mentions this sameness issue. And this is his answer concerning the question of whether iterative changes can change the identity of a constitution. And he says that it is still the same constitution adopted 200 years ago, just as a person who lives in the 18th century house lives in a house built 200 years ago. His house had been repaired, added to, changed many times since, but it is still the same house, and so is the constitution. In that sense, it is true that an old constitution is not the same as a new constitution, just as an old person is not the same as the same person when young. Sameness in that sense is not the sameness of identity. It is the sameness of all the intrinsic properties of the object. So constitutional identity is an indispensable concept for legal systems. Thank you very much for listening to me.
Thank you so much for delivering this, also under a little bit of time pressure, but thank you, it was very interesting. So I do realize that we passed our ending time, and I want to ask Sergey and Anna if we have time for a couple of questions or if we should try to conclude here.
I believe yes, we have to sorry, just I will switch to Russian time. We have to finish this session in 5:30. Now we have 4:44. So
okay. Well, I do suspect
almost 45 minutes to questions.
Okay.
I just want to be sure if we do not miss Ilker Gekhan Shen.
No, he spoke already.
Yes. Oh, yes, yes. Yeah. Sorry, it's probably me. IMS. Yeah, that. Then please open the floor for questions.
Okay, thank you. I do realize that some of you maybe have to go because according to the program, our ending time was 15 minutes ago. So, but I think since we have this group of people now, we listen to these interesting, excellent presentations, we should really not miss the opportunities to ask questions, post comments, etc. So please go ahead. You can either raise your hand using the raise hand function, or you can just post your question in the chat. It's up to you, and I'll try to give the word to whoever raises their hand. Celine, first Celine and then Helle. Celine, please go ahead.
Okay, thank you very much, Anna. Okay, my question goes to Gökhan, actually. You know, the populist regimes or populist governments, you said, transform the constitutional identity, and they also scoop up the meaning of the constitutional identity as well. And you gave really convincing examples related to Turkey. If you know, consider the eternity principles of the Turkish constitution, such as democracy, human rights, you name it, the rule of law. And, you know, your examples were or are very convincing to, you know, make this theory or to come to this conclusion as well. And we also observe that the constitution, the concept of the constitutional identity is used by the constitutional courts of many populist governments or many populist regimes as a reasoning of their, you know, judgments. And consider the Turkish Constitutional Court. The court hasn't named the concept of the constitutional identity even one of its judgments. As far as I know, it was referred only once in a dissenting vote, and that's it. So my question is, how do you assess or commentate, you know, the refrain of the Constitutional Court from the concept of the constitutional identity in its judgments? Do you think it's kind of a deliberate judicial attitude or something else? Thank you.
Thank you. Please go ahead. It was addressed to Ilker, right?
Do you want me to answer right away, or?
I think that's more efficient. So please go ahead.
Yeah. Okay. I think for me, from my perspective, the attitude of constitutional courts is maybe understood as in a general sense. For the court now, every decision or every case which has some sort of political nature is like a hot potato. And it's particularly after 2016, what we see the attitude of the court is, if it is completely against Erdogan, and this is unanimously, they decide for Erdogan. If there is something against Erdogan, but they have to decide, particularly because of their professional, because of their respect of professionalism, because at least half of the judges at the Constitutional Court are now to some extent respected constitutionalists. The other half is unfortunately just the clientele of Erdogan, who has no else qualification other than being a friend of them. So this is divided. This constitutional court is divided for the moment. And all the refraining of constitutional court is maybe understood from this divide, because at least half of them know that after this regime is ending, they will have to answer to the lawyers. They will have to answer to the democratic forces. Why did you decide that way? So including the constitutional identity and including other questions which are very delicate, the constitutional court tends to keep quiet for the moment, hoping that that question doesn't arise. The most particular example is the disclosure case, which was against the Kurdish party, the People's Democratic Party. It's the very good example of a hot potato. The Constitutional Court doesn't really want to deal with it, because if it has to decide according to the law, it has to dismiss this case. But there's a very distinct pressure from the political power, populist political power, for the dissolution of that party. So they're just playing the tennis game now, just because of some sort of, just by using some sort of formalistic issues, they want to procrastinate looking at this case. The court is just procrastinating to look at the case because either answer is wrong. So the constitutional identity may be subsumed under the situation, if it's clear for Professor Esen.
Okay, thank you. Helle, you had a question.
Yeah, thank you very much. It again, just a fantastic panel at a very impressive level. All presentations have been very interesting. I would like to first thank our last presenter, Gürkan Kasper, for bringing in a legal philosophical perspective to our discussions on constitutional identity, because I think that really brought an entirely different perspectives on how another lens, I would say, into our debates on constitutional identity. So thank you so much for that. My question goes to two of our speakers, Lauriane and Ekaterina, because they both spoke about how Hungary and Russia, how their constitutions have been amended so they protect constitutional identity. And because of that, I would just be very pleased, I think, to hear more about the amendment procedures of the constitution, especially maybe in Russia, since you're hosting the roundtable, but of course also in Hungary, because I think it adds an entirely new dimension to our constitutional identity debate at this roundtable, where we have been discussing, I think, a lot how can you sort of draw out the constitutional identity from the constitution? Is there actually even a constitutional identity in the constitution? But when you sort of add constitutional identity directly to a constitution, I think it brings in another dimension. So it would be fantastic to hear a bit more about the amendment procedures in Russia and maybe also Hungary. Thank you so much.
So maybe I first take the floor as the Russian and the representative of Russia. So may I clarify the question? You want to hear some procedures how we build our constitutional identity within the country?
Maybe Katarina, also on how can you change your constitution? How easy is it? Who are the actors who can amend the constitution?
Oh,
thank you.
It's so controversial question. So thank you. Yeah, thank you for it. Frankly speaking, we are having and we had many deliberations concerning the process of making amendments to our constitution, and the secret is that our head of the state he suggested some amendments, and these amendments were not so wide at the first stage of the moment, but then radically this transformation, these amendments were transformed, and from the 5 pages of this amendment, we as a result we shared with the documents with 70 pages and many amendments to the constitution. And also, in order to change our constitutional identity, the head of the state he transformed the procedure of making these amendments and interact the population of the country to vote for these amendments. There was a big company, marketing company, to support these amendments, and basically there was one, how to say, there was one very sad thing, because in the most, if we take the most of the population, there were no chance or guarantee that each person read the whole list of amendments. So that's why many persons vote for the human rights protection, human rights guarantees, but they didn't even expect that they voted also for some, for example, aggressive international policy or some close constitutional identity aside from some from international state and bodies. And so that was the problem, and that is the problem. And when the constitution was published in the final way after the election, after the process of voting, many experts were upset by this result, by these results.
Okay, Katerina, can I leave the floor to Lauriane, or you want to add something?
No.
Okay, thank you. Lauriane, please go ahead.
Thank you, Professor. Thank you for your question too. In Hungary, is very different. To amend the constitution is very easy. Is easier. For change the constitution, change of constitution and change in constitution is the same way. It's necessary to have two-thirds of parliament, and for example, the actual constitution, the Hungarian constitution, had 9 amendments since the beginning, since 2012, the date of its adoption. And it's only the Fidesz KDNP, which led by Viktor Orban, who adopt the amendments. And the Constitutional Court has not competence to provide an interpretation on the constitutional amendments, on the substantial content, since the 4th amendment, which had adopted in the year of the adoption of the constitution, of the new constitution. It's very different and it's very easy. It's very political.
Okay, thank you. Jakob, please go ahead.
Thank you so much. Also from my perspective to all of the presenters. So I have 2 questions and 1 comment. Like the first question goes to the, excuse me, to the Lauriane Alezat. And so if I understood you correctly, in a way, okay, so basically in interpreting fundamental rights, some extra legal considerations will always some kind of inform, or let's say influence the results, right? The outcomes of these ponderations, fundamental rights ponderations. But what you're saying is that basically the identity argument now kind of takes over this role, or kind of also assumes this role of well, influencing the fundamental rights protection. So my question to you is there a line between those extra legal considerations, or let's say factual circumstances, which are always kind of playing a role within the constitutionalism in front of the courts, perhaps not so explicit, but staying kind of within the legal commitment of a legal order, and on the other hand, using then an identity argument newly as a constitutional argument, which kind of is able to trump even certain fundamental rights. So my question is, should we like be cautious not to create or help to create this constitutional argument, which kind of now sits next to fundamental rights, basically, and has the power to overweight basically the majoritarian interests over the minorities. So that's my first question. The second question to the colleague Gökhan, I'm sorry if I didn't say this correctly.
It's correct. Completely.
It's just very short, and that is there a difference when we're, in your opinion, or is there a specific importance that we're talking about identity, or we could just draw all the conclusions that you're presenting simply by saying there's a normative constitutional order, it has these liberal commitments, and then we can play whether new amendments fit into this pre-existing normative role or not. So in other words, is there a specific reason that we should adopt this terminology of identity, or we could just simply equally say it's an essential features or constitutionalism in its normative sense? And just the third comment, I'm sorry that I took so much place and time, goes to one comment of the colleague Gökhan, who said that basically the German way of constructing pouvoir constituant is kind of ethnological, kind of one folk in that sense, if I understood you correctly. So I was just a bit confused with that assessment, especially in the light of the adoption of the German basic law was basically being forced by Americans. It excluded half of Germany, which then suddenly was being annexed without a new constitution, and so on. So I was just a bit confused with this assessment, but perhaps I just understood it falsely. Yeah, if you want to elaborate on that. Thank you so much.
Thank you so much, Jacob, for those 3 questions. So I'm going to let Lauriane answer first, and then Gökhan, and then Ilker Gökhan after that.
That's the same, yeah.
Thank you for your question, Jacob. Yes, I think it's dangerous to use the identity as an argument, but I think it's the role of constitutional court to be careful to not cross the red line and to interpret concepts which are very vague and which can be adapted at the states. And that's the very important role of the Constitutional Court, I think. Identity can modify the concept, can modify the human rights. And like I explained, the balances between the minority rights, which protect identity, minority identity, and an identity, collective identity, which diminish, which undermine the fundamental rights of this minority. For example, yes, but the Constitutional Court can be the mean to keep the pendulum and to keep the human rights guaranteed, I think.
Okay, Lauriane, thank you. Gökhan Kapar, please go ahead.
Yes, I think what I try to do indeed to establish a connection between constitutional identity and the discussions in legal theory about legal system, the identity of a legal system, and to think constitutional change or constitutional amendments from the perspective of legal systems. Sorry.
No,
Ну, вообще-то да.
Please check your mind.
Yeah.
Okay, it's okay. So, regardless of the quality of a legal system, whether it is liberal or illiberal, whether it embraces the basic principles of liberal constitutionalism. We need a kind of an idea of concept of constitutional identity or identity of a legal system. We cannot do without it. And here, you cannot reduce constitutional identity to national identity. For example, what Orban Erdogan is doing, in fact, reducing the concept of constitutional identity to national identity and presenting it as if their own constitutional identity is this. No, in fact, they are violating constitutional identity by using national identity. So what I try to do is that if you are approaching to a legal system from a temporal perspective, we have past practices and we have to accept it. And this is a fact, reality, and any kind of interpretation should fit at least to some extent those past practices. And law necessarily, by nature, is resilient to change. And we try to order the time by every kind of rule and every kind of principle we did. We are promising today to keep that promise tomorrow. And if you every time change your promise when you are implementing this promise, then we don't have law. It doesn't make any sense. And what I try to say is that we shouldn't reduce normativity to social facts, especially national identity, society. And legal positivists also are doing the same thing in some sense, at least from my perspective. It may be a little different interpretation, but that's what I think. Thank you for the question.
Thank you. Ilka, please go ahead.
Thank you, Jakob, for this question. Well, I use these models not as a analytically or conceptual clarification of the contemporary constitutional systems, but as a point of departure as a hypothetical term. As we know, it's in Germany, this ethnos is no longer valid, and at the same time, ethnos doesn't necessarily equate to a National Socialist regime. But in many cases, Carl Schmitt's conceptions are overlap with the ethnos conception. And today also, ethnos may be, or German model may be also another example of the progress of we. As of today, to become a German citizen, you can go there and you don't have to be the same blood, or you don't have to be in the same race. Also, from a perspective of constitutional theory, there's no ethnos here. There's a constitutional patriotism, which is where Germany is the source. So I don't even have to remind the post-World II constitutional developments, as you said. So they do not refer to an valid or practical historical case, but most particularly if you just compare it to social contract hypothesis, or it's like hypothetical situations, just as in France, in its revolution, it has many normative aspects of France, revolution of France, demos, but at the end of the day, right after 2 years only after, there was a dictatorship of Napoleon there, and there was no revolution. So these are all theoretical and analytical frameworks, most particularly practical, historical, taken from historical facts, of course, but now used as a hypothetical situation to analyze. Thank you.
Thank you so much. I'm going to take the advantage of being the chair before I hand over to Ekaterina, who has a question. And I have a comment for Cristina Gazzetta and one for Francesco. And the first concerning Cristina Gazzetta's presentation, it was a question or comment whether it would be maybe makes sense to look into the political and legal process in Estonia and Latvia in the beginning of the 1990s, when the question of citizenship, dual citizenship, and questions similar to the ones you discussed were being handled. And the Council of Europe was, of course, very involved in that process. So that's a comment. Maybe if there's some room for comparative constitutional law analysis, and could be interesting to see what you can learn from that. And to Francesco, I just wanted to say, I mean, it would be interesting to hear you reflect upon your own question, whether technology will kill democracy or strengthen it. Is my translation of how you posed the question. But I also would like to draw your attention to the fact that what you and your colleagues are discussing, the legitimacy and the representation of the parliamentary system in a time where we are meeting digitally, not in real life, physically, is very much ongoing in Sweden now as well. Because you might know that we restricted the number of members of parliament who can meet in chamber and in the chamber and assembly. And so many discussions, decisions, etc. are being they're being handled virtually. And right now there's a very intense debate on what it actually does to democracy, to legitimacy, and to representation. It's exactly the issues that you and your colleague discussed. So I want to thank you for also bringing the technical aspects into the issue of and the questions and discussion of constitutional identity. Appreciate that very much. I'm going to let you, Katarina, ask her question, and maybe then
Yes,
Francesco, if we can come back to you and you can, if you want to reflect.
Yes, I also want to ask the question of Francesca. To Francesca, so can you give us some negative or positive experience in Italy concerning the regulation of the technologies in your country?
Okay, thank you. So I'm going to hand over to Cristina and Francesco. Do you want to start, Francesco, and then Cristina, and then we're going to end this session? Please go ahead.
I just didn't hear the last part of the question of Ekaterina, please.
The
Sorry.
positive and negative aspects of technical
regulation in your country.
Who starts, Cristina or I? So maybe I start. Thank you for giving me the opportunity to answer this question.
Francesco.
Yes, the main topic is that we are speaking on about the constitutional identity and every kind of meaning and approach and perspective on this topic, but the main aspect of my speech was on the relationship between this identity, these fixed identities, wherever it means, and then ever changing world. And this contradiction, contradiction is the core of the law of new technology. So whatever it means, the identity, we have to face to an ever changing world. And as for the case of the Italian case of the regulation of new technology, there is no specificity of the Italian case. So it's not different from the general regulation of new technology in the European framework, as we can look at the example of the privacy regulation or the regulation of the relationship between liberty of freedom of expression, freedom of thought, and other forms of protection. And the way and the main topic is how to find balances among rights and among values and rights in a digital environment, where the balance is not fixed or is not the same as in the non-digital environment, for several reasons. Because first of all, because the decision is made by mostly private stakeholder. This is the first issue. And the presence of private stakeholder, even in e-democracy, is very relevant and changes the landscape of the balance among rights and values in the digital environment. And secondly is the main topic is the speed, as I said, the speed of the changing landscape. So every kind of legislation and every kind of regulation is always too slow for this world, or at least for the world of new technology, which is not the whole world, but a big part now. Thank you.
Thank you, Francesco. And Christina, please go ahead and you will get the last word and then we will round up this very interesting session. You have to unmute yourself. It should be down in your left corner. You can see a microphone. You need to tap it. Or maybe Anna Gritsenko, could you unmute Christina, please? You could do that as a host.
Okay. Okay.
Perfect. Thank you.
Okay. Est-ce que tu peux me reposer la question, s'il te plaît? Parce que je n'ai pu entendre.
Okay, so you want me to repeat? You didn't get the translation.
Oh. Unfortunately, I did not hear the question.
Estonia and Latvia and the political and legal debates and changes made in the beginning of the 1990s connected to the issue of citizenship and dual citizenship and nation building. And the Venice Commission and the Council of Europe was, of course, also very involved in that process. So it was rather a comment whether there were any parallels, interesting parallels to be drawn or lessons to be learned in regard to Europe.
Donc, je crois que la question, c'est de repenser les
It seems to be the question is to reconsider the issue of citizenship. That should meet the expectations. And it should reflect the joint values that people have. And at the same time, it should meet the general goal of every democratic state that should recognize, that should be a legal state and should allow for peaceful coexistence and safe coexistence of citizens. And I'm not talking about states that already have certain cultural deformities, for example, Canada or the United States of America, that have, or maybe Italy, that has certain cultural communities. And in Constitution, we have such communities mentioned that have certain historic aspects or linguistic peculiarities. And as for the Constitution of Montenegro, it should be the basic point for thought, I believe, taking into account the values that we all share. Because it's obvious that these values define the issue of belonging to some or other community, to the majority or to some minorities. And these shared values, they are particularly important, and they are taken into account by a democratic state in order to secure social well-being. And here we're talking about cultural constitution, but not about certain legal constitution in legal sense. And even the fundamental law can be defined as.
Thank you, Christina, for elaborating on that. And thank you to all the speakers. It's been a pleasure to spend this Sunday afternoon with you, listening to you and following your work. I think it's an excellent compilation of speakers that the organizers have put together for this last session. So great many thanks and good luck in your future work. I'm looking forward to reading all your important work in the future. And many thanks to Sergei and Anna and to the interpreters. And I think maybe we should give the organizers a 10 minutes break so they can prepare for the closing ceremony. But thank you all. Looking forward to seeing you in real life in the future. Soon, I hope.
Thank you, Anna. Let me correct a little bit. We'll have our closing ceremony in a little bit more than 1 hour. So I hope to see every one of you on the closing ceremony. And thank you so much for your contributions to our roundtable. Thank you, Anna, for chairing this session. and have a good luck. Thank you.
Thank you.
Okay, so 1 minute left. Celine, would you like to say something on the closing ceremony?
I think Hele will speak for all of us, for all the EC.
Okay, okay, perfect. Hele, I will start the ceremony and then I will give the floor to you. Good. Just wait, I think, 1 or 2 more minutes. Okay, so I think we should start our closing ceremony. Thank you all for participating in the round table. And these 4 days actually were quite tiring, but I believe they were very interesting discussions and very thought-provocative debates and many interesting and very bright, brilliant presentations. At first, I will give the floor to Helle Krunke, who will talk on behalf of the IACL, from the executive committee, from the president. Unfortunately, Edwin Stone is not able to attend our closing ceremony. In Melbourne, it's 1:30 a.m. So that's why she's not able to talk here. And Helle Krunke will talk on behalf of the association. Please, Helle, take the floor.
Thank you very much, Sergei. Yes, my name is Helle Krunke, and I'm the first vice president of the International Association of Constitutional Law. And I'm, of course, also a professor of constitutional law at the University of Copenhagen in Denmark. And on behalf of the ISL, I wish to thank the organizers of this roundtable, especially Sergei Belov and Anna Gritsenko. Thank you very much, and congratulations on a really wonderful roundtable. Furthermore, I would also like to thank Celine Essen and Jose Maria Serna from the ICL Roundtable Commission. You have all put in a tremendous effort into organizing this event. It has certainly not been an easy task because of the COVID-19 situation. A warm thanks to Sergei and the rest of the Russian team for making it happen, because I think this has really been a very important roundtable for the IACL. I am especially pleased that this conference has facilitated diverse scholarly positions and an open and dynamic academic debate among speakers and participants at the roundtable. An open academic dialogue is crucial for a scholarly association such as the IACL. We must always be open to listen to each other's academic positions, and there must always be room for academic critique and also contradicting positions. This is part of academic freedom, a value of great importance to the IACL. Now, during the past 4 days, we have listened to many wonderful and really rich presentations of a very high academic quality. And this includes the young scholars panels, which have been very impressive. Now, our host, Sergei Belov, has asked me to highlight some points from the roundtable. This is, of course, not an easy task. We have been here for 4 days listening to all these wonderful presentations. So I've decided that maybe one way to do this is to simply draw on the many questions which have been raised and which seem to be actually an important output, I think, of the roundtable. What is constitutional identity? And should we distinguish between constitutional identity and national identity, as stated by Michel Rosenfeld? How do we interpret constitutional identity into the language of jurisdictions which are not familiar with the term? Such difficulties in a Chinese context were highlighted by Han Dao-Yuan. As many of the presentations, for instance, from Asia showed, constitutional identity is not a familiar concept in all jurisdictions. Tiu Lian from Singapore expressed it in a rather colorful way in her presentation when she said that she would try to get a grip of the beast. Another colorful contribution came from Pablo Ribeiro, who explained constitutional identity in Argentina through the metonymy of a movie entitled The Hands of Olaf. And apparently this is a movie about a person who's transplanted the hands of another person. Very fascinating. Yet another important question is who should define constitutional identity of a country. Normally, this role would go to the constitutional courts or the Supreme Courts, which leads to another important question. How do we define a country's constitutional identity? Should constitutional identity be drawn from the constitutional text as a starting point, as pointed out by our Australian colleague, Will Bartlett? And which interpretation techniques can be applied when interpreting the Constitution? This was, among others, debated at the 2 panels today, which were very, very interesting. Other speakers at the roundtable put more emphasis on context. And one could also ask, should tradition and history play a role? And in that case, how much emphasis should we put on tradition and history? And is history individual to nation states, or do we share common history and experiences across the globe, for instance, based on our shared experiences from the Second World War? Such shared experiences are the background of many international and regional treaties, including the Universal Declaration of Human Rights, the European Convention of Human Rights, and the treaties also of the European Union. And the goal of these organizations is to avoid wars, to protect individuals against abusive and arbitrary state power, and to protect human dignity. And these are goals which seems to be very relevant globally, also in today's world. One of the main points of debates has been the interplay between national constitutional identity and international and regional treaties. Because some constitutional courts in certain cases have applied constitutional identity as an argument not to follow the European Convention of Human Rights or maybe European Union law. And in some cases, this has also been met by critique. And this was also reflected in some of the academic presentations at the roundtable, for instance, at the first panel we had today. In general, I think several interesting remarks have been made regarding this issue, this relationship between the national constitutional identity and international and regional treaties. From the Russian context, George Gatchev stated that universality and fundamental human rights values actually build on a Western liberal way of thinking. However, Charles Saunders from Australia remarked that liberal democracies are also different from each other. And in general, she said, all constitutions have borrowed and transplanted from other constitutions. So does that mean that international and European cooperation maybe is all about focusing on our similarities and not on our differences? In other words, focusing on the common good in a European or global context, which will also mean that sometimes all involved countries will have to set aside their national interests and traditions. Focusing on similarities and common values is much in line with theories of EU constitutional pluralism, and other topic which was discussed at this conference. Two of our young researchers on one of the really brilliant young scholars panels, Toni Fickentescher and Raphael Eutmann, critically analyzed the judgments of the German Constitutional Court on constitutional identity, concluding that the court has gone too far in its interpretations of constitutional identity in the German constitutional context. Fickentescher also suggested that national constitutional values should be interpreted in accordance with the corresponding EU constitutional values, and that constitutional identity can no longer be driven only from the national level. Gerhard van der Schiff even argued for the existence of an EU constitutional identity expressed through the common values in Article 2 of the Treaty of the European Union, an argument which was also raised by other scholars at the round table. Constitutional identity as a concept is contested, and the past days it was asked what the relevance of the concept is. For instance, Sharon Saunders mentioned that she is skeptical of the concept for several reasons. It's too static, it is subjective and selective, it can be used to isolate parts of a constitution, and it is used to set barriers to EU law and to regional institutions. Michel Rosenfeld pointed out that the concept in itself is not the problem. However, the concept has been hijacked and misused, as he put it. According to Gary Jacobson, we have to make a distinction between the concept of constitutional identity and problematic applications of the concept. Cesar Landa from Peru, which is a multicultural country, pointed out the challenges of determining, for instance, who the people is in a multicultural society. In general, one might ask how diversity and minorities can be protected by constitutional identity. Often they are in fact excluded. And this was pointed out by several speakers during the roundtable, and it was especially, for instance, ethnic and religious and political and sexual minorities were emphasized in that regard. The challenge is also, or was also reflected in the papers which understood constitutional identity as consensus. Because is there ever a consensus? At least not in a democracy. And I think in Sweden, which I believe is the country, the one country in the world, which is the most optimistic about finding consensus, even they would probably be a bit skeptical to finding this consensus, because that is certainly quite difficult. Many more interesting questions have been raised during the conference. I would have loved to go into many more of them. However, I simply do not have the time to include more of the arguments raised at the conference. So please allow me to wrap up. At IACL events such as this event, we meet and we connect. And when we leave, we have gained a better and a richer understanding of other legal systems and cultures, especially when we meet physically, but also when we meet online. We form friendships, and friendship bind people together. Plato knew that. And in the ICL, we experience it every single time we meet. This is the essence of our association. And I therefore invite all of you to join the association. If you are not already members, we also accept individual members. Sign up for our blog, join our research groups, and attend our roundtable, such as this one. The next roundtable will take place in January, and that will be at the University of Copenhagen in Denmark. And the topic is the impact of digitalization, new technology, on constitutional law. We aim for a hybrid event, and soon you will be able to find more information on the IACL homepage. Furthermore, the IACL World Congress will take place in South Africa in 2022. You can read more about that on the IACL homepage, and we would love to see all of you there. So finally, let me just repeat my warm thanks to our St. Petersburg hosts for an excellent and a rich roundtable, which reflected many different views on constitutional identity. It was simply fantastic, Sergei. Thank you so much.
Thank you so much, Helle. Thank you for your kind words, and thank you for your summarizing the debates which we heard during these days. I will say a few words on behalf of the organizers, but before I will switch to some methodological and organizational things, I will say a few words about my impressions about the debates. I think we had a round table about the constitutional identity. So many speakers were very skeptical about this concept, this notion of constitutional identity. And I think one of the main reasons for this, of course, is misuse of this concept, but on the same time, a kind of vague meaning of this concept, at least in the jurisprudence. I mean that the notion of identity was borrowed by legal theory from social or political sciences, and maybe borrowing, we were not that exact what we mean by constitutional identity, where we should find it, and who should define a constitutional identity of a state. The correlation of constitutional identity with national identity and other questions arise from this vagueness, I believe. To my view, we talked sometimes from quite different perspectives on what constitutional identity is, and for me was a little bit surprising that most of our speakers talked about constitutional identity more in methodological or instrumental meaning. I mean that the questions about the correspondence between the international or supranational legal orders and national constitutional systems, the core of national constitutions protected from amendment. These are those what I believe is rather instrumental taking of constitutional identity idea, but I believe that it has some value dimension, and of course we can talk about constitutional identity only and that scope when we differ. Of course, if we declare that human rights or the rule of law or separation of powers is constitutional identity, looks quite strange to me, because this is the common for constitutionalism, for constitutional systems in different regions and in different cultures, but the differences should be marked as identity. But still, we need more debates and more dialogue about this notion, both on its understanding and on what it means in separate constitutional systems. So I think it was quite interesting that Michael identity.
Taka, you are falling out.
I'm so sorry about this. This is the losing of connection. So I hope this is the scope for dialogue, both in international and in national levels. So I believe that our roundtable could be a small contribution to this dialogue, and hope it will have some outcome for the theory of constitutional identity. I have to say many words of gratitude, and probably the first my words will address all the speakers and all the chairpersons who made their brilliant contributions to our roundtable. We had quite different contributors. On the one hand, we had those world-known experts and scholars who published one of the most famous books on constitutional identity. I mean, Professor Jakobson and Professor Rosenfeld here at our roundtable. And on the other hand, we had young PhD students who have identity, national identity, constitutional identity as topics of their PhD theses, and I believe it was remarkable of dialogue between different generations, I would say. And of course, I express my deep gratitude to the association. I do believe that it was a very important step that we could organize the first IACL roundtable in St. Petersburg and in Russia at all. Since the foundation of association, it was the first event of IACL. And of course, we are very sorry that we could not welcome you physically in St. Petersburg, but I do hope we could do this in the nearest future. And I will express my gratitude to Adrian Stone and to Selin Essen for their help in organizing this roundtable. Of course, without their support, we could not manage to organize our roundtable. Thank you so much. And I will also express my gratitude to my team, Anna Gritsenko, to Irina Nikulina, to Yulia Yaluner, and to many others who helped me with organizing this roundtable, and who did very hard work for making all this organized. And I would also express my gratitude to our entrepreneurs who helped us, who was with us during these 4 days, and who organized the translations both to Russian and French, though most of speakers spoke English, but we gave opportunity for those who want to follow us in Russian could do this. We organize both Zoom conferences and broadcasting on YouTube, as you know. By today, we have more than 1,500 views in the Russian channel of YouTube, about 300 in English, and about 100 in French YouTube recording. But I do believe that these numbers will increase in the future, because we will keep all these records on the YouTube. I will send you all the recordings links for you to share them, and hope that our roundtable will keep these materials to be used in the future. I hope we will be able to organize the transcript of all the debates on this roundtable, and of course, having the consent from all the participants, we will publish it in our materials. I would also invite all the participants to make contributions to edited volume. I mentioned that in the beginning of the round table. If we will have enough participants, enough contributors who would prepare articles based on their presentations, I hope we could organize publishing a separate volume on the as the outcome of our roundtable. The last point, maybe not the least, but the last point, I should say thanks to our partners who supported our roundtable with financial support, and these were our law firms Grigoriev and Partners, SNK Vertical, and DLA Piper. Only the last one is the international law firm, but first two are Russian law firms who supported our initiative, and I do hope that with their support we will organize our next event, which I believe will follow, I mean, the next events of IACL. So if someone would like to say also a few words on this ceremony, please take the floor. And if not, so again, thank you all, and keep in touch.
Thank you. Bye-bye. Thank you, Hele, for the words. Sergey, wonderful speech. We are very grateful for everything. Bye-bye.
Thank you. Thank you. Thank you.
Bye.
Bye.
Thank you.
See you next
Thank you very
time.
much.
See you. See you.
Very much to take part in this conference. Thank you. Bye.